Yes,
Lordship, item number 4, Lordship.
yes.
I need some accommodation for today, Lordship. I have some fixed part heart mattress in other courts, Lordship.
3 with 4.
So 3 is also tagged together.
Yes, 3 is also take together. If 3 can be continued, then it can be done. I can do my part later.
Let us.
Lordship.
On the prayer of Mr. Kolita, learned counsel, amicus curiae for the appellant in 4. Has sought an adjournment in respect of criminal appeal numbers. So, Mr. R. Sharma is available. Learned amicus curiae
You mentioned.
and MS S.H. Bora, learned counsel for a respondent. Additional public prosecutor for a respondent state are present and have no objection to the yes. Take list the appeals. After 2 weeks,
Lordship. Oblige.
get to be fixed by the office.
May I please? My lord, I am extremely sorry, my lord. Item number 2.
Yeah.
My lord, today I have some, my lord, problem, my lord.
Okay.
Can it be after vacation, my lord?
Okay. Yes, MS Bora.
Lordship.
You are for the
Appellant, my lord.
appellants.
Yes.
Okay, Mr. On the prayer of Mr. M.U. Mondal, learned counsel for the appellants. Let the case be listed after the ensuing summarization. MS S.H. Bora, learned additional public prosecutor for the respondent state. He is in attendance and has no objection. Office.
Deep Lord bless you.
May it please Lordship. Item number 10, kindly adjourn the matter for the day. Not 10.
You are Mr.
N Islam.
Lordship, in this matter, there is a issue as regards service. I have served copy on the other side. On the last occasion submitted, Your Lordship, last to last occasion, but nobody is appearing on behalf of the
Okay.
victim.
Boxometer
Yes,
Okay.
sir.
orders. When?
Lordship, 19 or 18, Lordship.
On the sign of the review. Deep.
Daily list for hearing item number 1.
Yes.
Lordship. 302 Lordship.
302.
Yes, Lordship. Here also he is 10 years, 10 months inside. All along he was in jail, Lordship. The informant is the eyewitness and he is accompanying with the deceased, Lordship.
Hmm.
The Ajahar Lordship at page 4. Humble submission is that on 16/8/2013, my younger brother Jayanta Das and I started off for Kolkata in a vehicle bearing registration number so-and-so after loading chemical in it from a chemical factory in Namrup. My brother Jayanta Das picked up 3 acquaintances of him from near an oil depot in Namrup and brought them with us to Sibsagar. We chatted and exchanged tobacco, betel etc. along the way and ate roti, etc. in a Punjabi hotel at Sibsagar. They did not get down at Sibsagar, saying that it would be inconvenient for them to go home at such late hour of the night and continued to travel with us, saying that they have acquaintances ahead of the road. At about 2:30 a.m. on 17/8/2013, my brother shouted Oma and telling me that he had been stabbed. My brother halted the vehicle. The accused assaulted me too before fleeing the same scene through the window of the vehicle. Although I seized them, I could not apprehend them. I raised alarm, but none came out. I took my brother in 108 ambulance service to the civil hospital, but he died while under treatment there. I can identify those killers if I see them. So far as the description of the killers are concerned, they speak the language of the T tribe. Later, I came to know that this incident of killing had taken place in Sariagaon bypass and that the name of one of the killer is Naresh Das. I know that he hails from Sonari Sapekhati and that the rest of the accused are his companion. So, Lordship, in this Azahar, name of Bijoy Sonar, the present accused was not there. Only Naresh Das' name is there and Naresh Das was declared absconder, Lordship. So he is the main witness, Lordship. The first 10 PWs were examined. So the informant is PW2. PW1 is the person who had only signed when police is taking sees the
Commitment order.
Lordship. Seven 11/2014 order. Accused Bijoy Sonar is produced from jail custody. The EO, namely Dilip Kumar Sutia, is present, who is examining CW1. He has proved the report of proclamation issued against accused Naresh Das as Exhibit 1 and the report of attachment issued against the said accused as Exhibit 2. CW1 has stated that in spite of attempt, accused Naresh Das, son of so-and-so, was not found in the locality and his present whereabout is not known. The NBW issued against him is kept in the police station for future execution and a separate report is filed before the court which is exhibited as Exhibit 3. After going through the material on record and after having learned additional public prosecutor, I opine that the said accused has absconded and therefore accused Naresh Das is declared as absconder and the case against him is filed. The bench assistant is directed to prepare a supplementary case record and to put up the same either on appearance of the accused or on his arrest on the strength of the NBW. The original Exhibit 1, 2, and 3 be kept in the supplementary record, keeping photocopies of the same in the committal record. Copy is ready and the same is furnished to accused Bijoy Sonar. Perusal of the record, including the report under Section 173 CRPC, reveals that the accused has been charge sheeted under Section 302, 323, 34 IPC, which is exclusively triable by the Court of Session, and therefore the case is committed to the Court of Honorable Session Judge Jorhat. Accused is remanded to jail custody. The Superintendent Central Jail Jorhat is directed to produce accused Bijoy Sonar before the Court of Honorable Session Judge Jorhat at 10 a.m. So and so.
So Naresh Das was declared absconder by following proper procedure.
Yes.
Yes.
PW2 is the informant.
What are the charges?
302 and 323.
302 against Joint Das
Yes,
and 323
against
against
the informant.
informant. Okay. So informant is an injured witness.
Although his injury was medical report doesn't say, but only heel in his heel some.
Whatever,
Yes,
injury
Lord.
is injury.
Yes.
Injury may be simple, injury may be grievous. Yes.
PW2. I know accused Bijoy Sonar, who is present in the dock of the court today. I also knew this is Joyanta Das, who happened to be my younger brother. He was the driver of the ill-fated tanker in which the incident took place. Occurrence took place less than about 2 years ago in the month of August. On the date of occurrence, we were coming back from Namru. Accused Bijoy Sonar, co-accused Naresh Sir, and 2 boys were also present in the tanker. All of them requested before us to take them to Sibsagar. When we arrived at Sibsagar, we all took dinner in a hotel. When we again boarded the tanker and arrived near Sariagaon bypass, I heard my younger brother shouting. At that time, I was sleeping beside the driver's seat, which was the seat of the handyman of the tanker. Hearing the shout of my brother, when I looked towards him, I saw accused Naresh Sir assaulting my brother with the help of an iron instrument like lever. At that time, accused Bijoy Sonar helped co-accused Noreshwar in assaulting my younger brother with the help of the lever. When I saw them assaulting my younger brother, both accused persons also assaulted me and thereafter threw me out of the tanker, as a result of which I fell down on the ground and received fracture on my leg. The tanker was stopped by my younger brother and he requested me to call his friends, but as I did not know anyone, I told him to call his friend. My younger brother had a Chinese mobile along with him. He called his friends to the spot. The accused persons, namely Bijoy Sonar and Noreshwar, were known to my younger brother from before. Two of the friends of my younger brother arrived at the spot and thereafter called 108 ambulance, and thereafter we were shifted to hospital for better medical treatment. My younger brother succumbed to his injuries at the hospital at about 5 p.m. On the same day, the two friends who arrived at the spot were Lakhindra and Mukunda. I lodged Ejahar before police. I put my thumb impression in the aforesaid Ejahar. I also gave statement before the magistrate where I put my thumb impression in the respective sheet of paper. Cross. Police had examined me. I am a resident of Borpeta, Nepali Basti. Accused Bijoy Sonar was the handyman of the aforesaid tanker in which my deceased brother was the driver. Accused helped my brother at the time of puncture of the wheel of the tanker. From the state of Kerala, accused Bijoy Sonar accompanied my younger brother. I boarded the tanker at Borpeta district. Accused Bijoy Sonar was accompanied by Noreshwar and two other boys from Namru. Noreshwar and my brother were in talking terms at the time of traveling in the aforesaid tanker. All of them requested my brother to take them towards Sibsagar district. Co-accused Noreshwar was also a driver by profession. Noreshwar was sitting at the backside seat along with accused Bijoy Sonar and two other boys. Accused Bijoy Sonar was sitting at the left side of Noreshwar. I was sitting in the handyman's seat, which is just beside the driver's seat. Accused Bijoy Sonar was sleeping at that moment. I was also sleeping. Accused Bijoy Sonar slept from Namru. When we arrived at Sibsagar district, all of us came down from the tanker and took lunch at a hotel. I did not hear any talk between my brother and accused persons. The two boys did not talk with my brother. The accused was sleeping all the way from Namru. Noreshwar took 2 chapatis and consumed liquor at the hotel. My younger brother also consumed alcohol. I heard talk between accused Noreshwar and my deceased brother. Accused Bijoy Sonar, after having meal in the hotel, again slept in the tanker. It is not a fact that I did not state before police that I was assaulted by both the accused persons and thereafter both of them threw me away from the tanker, as a result of which I fell down on the Pakka road and fractured my leg. I do not know if there was any money transaction between my deceased brother and Noreshwar. It is not a fact that I have deposed falsely in the court today. So, Lordship, in pros, he had not stated anything against Bijoy. He was all along sleeping as per pros, Lordship. And one thing, Lordship, in Ejahar, he had mentioned that 3 acquaintances of him. Jantoda speak up 3 acquaintances of him. So here, Lordship, in that way, Lordship, Bijoy Sonar is already there because his examination and chief is also there that he is traveling from Kerala, Lordship. So these 3 persons, possibly Noreshwar and other 2 accused.
But FIR is silent as well as this PW2 is silent about whereabout of the accused immediately after the incident.
Bijoy Sonar. Lordship, he had in 313, he had given that explanation.
No, when he was
had
arrested,
stated that he was not present. He admitted that he was present in the tanker. And seeing the fighting, he fled away to his own house, and from 18/8, he was arrested from his house. That is his 313 explanation. He was sleeping. That is also he has stated at the time of incident, and that is corroborated by TPW2 in his cross.
When he was arrested,
18-8.
next day.
Yes, Lordship. IO's evidence is there that he was arrested on 18-8 from his house.
Sunar was arrested from the house of Naresh Das. Naresh Das was absconding, but Bijoy Sunar, he was taking shelter there. Some kind of weak inference could be there that brothers in arms. Let us proceed.
Lordship.
Not from his own house. Not from his own house. He was apprehended from the house of Naresh Das. Which one you were reading?
I completed PW2.
Yes. We have completed, I think.
Yes, Lordship. PW2 is complete. PW3 and PW4 are two friends of the deceased. According to PW2, the deceased himself called them, Lordship. But possibly there is no phone record was examined whether it is actually, because those facts were not stated in the Ejahar. And as per the Ejahar, he himself called the 108 ambulance, PW3. I do not know the accused who is present in the dock of the court today. I own a tempo. My relative brother Lakshindra Nath knew the deceased. On 17/8/2013, occurrence took place. My related brother Lakshindra was informed over phone by the deceased that there was a dokaiti being committed in the tanker. On hearing the incident, Lakshindra along with myself came to the spot. The driver of the tanker was found alive at the driver's seat. He was at that time conscious. The driver stated before us that the handyman and one Naresh sir had badly assaulted him along with his elder brother. We also found the elder brother of the driver lying on the road. His leg was fractured. The driver requested my brother to save him. Accordingly, my brother informed 108 ambulance, which later on arrived, and both the injured persons were shifted to Jorhat Medical College and Hospital for better medical treatment. Driver stated before us that accused Bijoy Sonar and associate Naresh sir had assaulted him with the help of a lever. We did not find Naresh sir near the place of incident. Thereafter, I came to Bhugdo outpost and informed about the matter. I did not visit the injured person at Jorhat Medical College and Hospital. Chemicals were present in the body of the tanker. The driver was found sitting in the driver's seat at the time of incident in an injured condition with blood oozing out from the wound. I was also present at the time of seizure of document of the tanker by police. Exhibit 1 is the seizure list of the document of the tanker vehicle, and Exhibit 1-1 is my signature thereon. I was also present when magistrate held inquest over the dead body. Exhibit 2 is the inquest report where Exhibit 2-1 is my signature. Cross. Police had examined me. I do not know where from the tanker had come from. I also do not know how many passengers were traveling in the aforesaid tanker. When I reached the spot along with my related brother, I saw the driver as well as his elder brother at the spot. The driver was at that time alive and he had telephoned my younger related brother. I did not have any conversation with the driver of the tanker. My related brother talked with him. I do not know under what circumstances the incident had occurred. It is not a fact that I have deposed falsely in the court today. Then the PW4. I know accused Bijoy Sonar, who is standing in the dock of the court today. He was working as a handyman of my private vehicle. This is John.
That you were the appellant was inside the cabin of the vehicle. That has been admitted
Yes,
in 313.
yes.
There is no doubt about it. Yes, in fact, he was in tune with the PW2 that he was inside the cabin of the truck at the relevant point of time. And in 330, he wanted to shift the burden to Naresh sir. Is it not? Page 34.
Lordship.
He is an injured eyewitness.
But fracture is not proved, Lordship. Not
Page 10.
page.
Medical report is there.
Medical
Fracture.
report is there, but only fracture is not there. Fracture is not there.
So, would it defeat the prosecution case, entire prosecution?
Lordship, one hand, this Bijoy Sonar is traveling with him from Kerala. The other 3 persons are not known to, whether known or not known to Bijoy
He's
Sonar.
not known because PW2 has clarified that he is otherwise not involved with the truck. It was his brother who was the driver. He boarded the truck when it was coming back from Kerala at Borpeta. Then they went to Namrup. Then at Namrup, these acquaintances of his younger brother boarded the truck. Then they traveled to Sibsagar. Sibsagar, they had at a dhaba, they had their meal, also consumed liquor also, betel nut or all. Then they wanted to drop down at some place else. That is their version. That is the PW's testimony. Then at midnight 2:30, the incident occurred inside the cabin of the truck. Then brother, on being assaulted, he stopped the truck. Then this man was thrown out. He has aggravated his injury by saying that I received fracture. But he was found near the, and this is also telling that he does not know this PW 3 and 4. PW disease are known to these witnesses, not 3 also. 3 also said. 4 is known to the disease. And there was a call. Call is not proved. But their appearance at the place of occurrence immediately after the incident is found from other evidences corroborate that seizure of truck. I have seen the case diary, seizure of truck, then taking them to hospital. They were there. So it was, tanker was taken to Bugdoi outpost. Then the injured was taken to hospital. They were all along there, both of them. PW3 is a related brother of PW4. So he accompanied PW4. And he said that whatever was disclosed by the injured, who later on succumbed to his injuries, it was disclosed to his PW4.
So whether it is believable who had severe stab injury, he called himself and everything is.
You have admitted their presence. Your presence.
Lordship, yes.
You admitted your presence inside the cabin at the relevant point of
And
time.
then,
Only thing is that you said Norris.
yes,
Norris did it. I did not do it.
because PW2 is also supporting that he was all along sleeping, and this is what he has stated 313 that he was sleeping and hearing hue and cry. The PW2 has also stated.
The
that.
incident of inside a cabin, how
This gas-
how big it is?
gas-
Hardly 8 feet by 5 feet, the cabin. Hue and cry is not at an open place or somewhere in a house or a courtyard or somewhere. Hue and cry is 8 feet by 5 feet. One, imagine yourself inside a cabin. One hue and cry is enough to wake a person from sleep. But your explanation, you have said that you were there.
He admitted that much because he's present. And one more thing, whether actually 3 acquaintances, Naresher and 2 other persons. Azahar is silent about Bijoy Sonar. Bijoy Sonar was already there, Lordship. These 3
Already there. He was already there.
He was from early time he was there. These 3 person arrived and these 3 person are known to the deceased, Lordship. They have not came as per the instruction of this accused, Lordship. If the Azahar is very much silent about Bijoy's involvement, Lordship, Noreshwar and 2 other person who had entered that. But if that he must have developed the case, Lordship, the PW2. Even in 164 is also developed because 164 is on 5/12 and incident is of 8, Lordship, August. And
Explain your abscondence. Explain your abscondence also.
Lordship, seeing such a situation that he had already stabbed, and stab injury is also front to back, Lordship.
You also got it. But you were arrested from Norris Das house. We wanted to accept that position that he is seeing this gruesome incident, he played away. That is not an inference, but finding you in the house of Norris Das.
Possibility that there may be possibility that he is there, Norris is also there. He may have given him the assurance that I will abscond you also. That may be a possibility because injury is from front to back. and the person accused are sitting backside. So how from front to back he was driving the vehicle? So there is no question that he had left his place, and so they could step. The person is driving; he was already in the driver's seat. So from front. Weapon is also somewhere it is said liver.
Declaration.
That is seeing the condition of the accused. He died immediately, Lordship, and these two
Not
were
died. Not
taken
died,
in
madam.
hospital, but
Not died, madam. Each of them, PW2 and PW4, and supported by PW3, said he did not die at that moment immediately after the
taken to-
incident. And somebody said on the next day he died. It is possible that he did not lose consciousness because these two persons were informed. These two persons were informed.
involvement of information is also not in the Ejahar. Yes, but Lordship may kindly see the Ejahar. What is the in the written in the which is immediately.
How did you put it? FIR is not substantive piece of evidence. Now, how did you contradict it? It is for the purpose of contradiction. How did you contradict? It should not be encyclopedia. It is for your use. FIR to contradict, which is the testimony of the informant in the court. What did you do?
That is in most of the jail appeals, Lordship. That is the difficulty.
Even private appeals also. Aru ki sir? Okay, let us see the IO.
Lordship.
Injury to PW2 is simple.
Simple.
And what about the injury to the disease?
Yes, Lordship. 26, page 26.
Stab injury.
A stab injury of 4 centimeter into 1.5 centimeter into peritoneal cavity deep present on the front of abdomen, left side 2 centimeter away from an at the level of umbilicus in the left lumbar quadrant. The injury is obliquely places, middle shape with well-defined clean-cut injury. On dissection, the injury passes through skin, subcutaneous tissues, muscle, norms, and vessel, peritoneum, underlying intestines, and found perforated at places. The direction of injury is front to back, left to right, and slightly above downward.
It is homicidal. No doubt about it. Now, question is intention. Question will be intention and how it is linked. Let us see the
Ayub,
testimony of the IO.
Lordship. Ayub, Lordship, page 19. Charles Bhogdoy outpost received telephonic information about the incident. At about 9:30 a.m., I, along with the in-charge Bhogdoy outpost, visited the place of incident. One Ejahar was lost by the informant at Bhogdoy outpost, which was sent to the Jorhat police station for registration of a case under proper section of law. The Ejahar was registered as so-and-so. After visiting the place of incident with the in-charge, I also drew one sketch map of the site of occurrence with index. Exhibit 7 is the sketch map. Sketch map was drawn by me in my own hand. 3 witnesses of the incident case was examined by me, whose name was Sri Rupam Bharali, Kumud Das, the complainant and of the case, and Sri Lakhindra Bora. I did not find the dead body of the deceased at the place of incident. I only found the dead body of the deceased after my visit at Jorhat Medical College and Hospital. One tanker was found at the place of incident. Tanker bore the registration number so-and-so, which was filled with chemical. After my examination of the vehicle, I noticed blood stain in the cabin of the tanker, When the tanker was brought to the police station, it was again searched. On search, I found one sword from the toolbox of the tanker. The tanker was seized by scissor list so-and-so in presence of witnesses. The sword was also seized in presence of witnesses by scissor list so-and-so is my signature. Material exhibit 1 is the said seized sword. I also visited Jorhat Medical College and Hospital where the dead body of the deceased was kept. Accused Bijoy Sonar was arrested by me on 18/8/2013 from Kothia Khanda village under Sapekhati police station.
Let us see the search sheet. Whose address is it is?
Just,
Page 69.
Your village is different. Nor is this village is Kotia Khunda. Your address is Rohan Bhalak Bill. Yes.
I also accused Bijoy Sonar was arrested by me on 18/8/2013 from Kothia Khanda village under Sapekhati police station. Inquest was held over the dead body of the deceased by the executive magistrate in presence of witnesses. Thereafter, the dead body of the deceased was sent for autopsy. Kumud Das, the elder brother of the deceased, was also medically examined by a doctor who was also injured in the incident. I also took his statement. The statement of Kumud Das was recorded by the magistrate under section 164 CRPC. The tanker, which was seized by me, was inspected by the MPI. The report of the MPI has been submitted before the court, which is appended with the case record. As I cross. The information was received at Phugdoi outpost at about 9:10 a.m. on 17/8/2013. After receipt of information, I went to the place of occurrence at about 9:30 a.m. Aforesaid information was entered in GD entry so-and-so dated 17/8/2013. In the seizure list also there is mention of aforesaid GD entry. The sword was found in the toolbox of the tanker, which was closed at the time of search. There was no blood stain present over it. I examined the complainant of the case, who is examined by the prosecution as PW2. Complainant did not state before me during his statement under section 161 CRPC that he was assaulted by two accused persons and thereafter accused person threw him from the vehicle for which he sustained fracture on his leg. I examined complainant on so-and-so at about 1:30 p.m. at Phugdoi. The tanker was stopped at the middle of the road in a declined position. With a liver. And the injury, the
That sword is not,
blood stain was not there.
and you're not telling with the PM report also. PM report says
Pointed circle.
prima facie that moderately something. Moderately
Heavy sharp cutting. Pointed. Page 78.
is 78. 78.
8.
Moderately heavy. sharp cutting pointed weapon. Darkness over an cabinet to darkness.
হয় darkness থাকিলে কিন্তু সেই লাইট জ্বলি থাকে ন ফ্ৰণ্টত অলপ পোহৰে হেৰি হৈ থাকে
Question number 3 also, apart from the last question. Answer, I was present in the tanker at that time. But he said, I did not.
Assault anybody. He could have said that he was not present, but he had admitted that he was present. I have,
Aggressor had committed the crime. So commission of crime is also admitted by this man.
he had seen that something was
I
happening.
did not help.
Narrator in assaulting the informant and his younger brother. I was sleeping
I
at
did
the
not
time of
help.
incident inside the tent.
In assaulting the informant and his younger brother. He also indirectly acknowledges that there was assault on PW2 and the deceased. What he is not admitting is that he was not the person. It was Narrator. Mohan.
At best, he could have been 34 if he is not an absconder. His involvement at best up to 34 lordship. But when the
34,
main accused, they have
then
not
Brathi comes in.
main accused his house is known. Lordship may
Court
kindly
has to proceed taking all these things into account.
it
If
has
he
to-
is in aid,
it has to be
if
beyond
he is in
reasonable
aid,
doubt.
then he will be similarly punished.
But they have not tried to arrest that because his house, his family is residing.
Proclamation and attachment is there, and thereafter you cannot say that is an order of the court. After reaching a satisfaction by the court has issued proclamation and NBWA. In the face of such material, you cannot say that there is no effort to apprehend Norris. That submission will not do.
And
That is not there because that is why I
Lordship
wanted it to read that order
committal order.
for
Lordship-
that purpose, so
yes.
that this submission will not hold.
Lordship, Lordship may kindly come to
Practice,
164 statement, Lordship. I want to show that how he is changing his person of statement, Lordship. The PW, although he had enough time to develop his 164 because as per the date is 5/12 and incident is of night of 16/8, Lordship. Then also, Lordship, there is some contradiction in his evidence regarding, and he had also submitted that this person is all along sleeping.
It's a money laundering. Have those contradictions were brought on record. Those contradictions,
Lordship, at the trial stage, possibly not, but here we are at the appellate stage and this should
what to
have been
do?
beyond reasonable doubt, Lordship. This is not a case beyond reasonable doubt.
We are trying to see, but not going towards that direction.
Only 164 once, Lordship, and I just
330
want to read it, Lordship.
You have to go over. Had,
Yes.
had you offered other kind of plausible explanation in your 313 examination, things might have been, could have been different. But in the face of such explanation,
But it-
that is admitted.
prosecution has to prove it beyond reasonable doubt. Lordship,
We are
one,
testing on that, yes.
79, Lordship, kindly once, 164. It was on 5th day of December, so after almost 4 years. About after commission of the offense,
After 4 years.
4 months, sorry, 4 months of commission of the offense.
Value আছে।
164 was.
immediately কৰিব লাগে বুলি আছে
The law is settled after 4 months, it has no value. Which one use?
Yes, Lordship, may I? This is Jayanta Das, is my younger brother. Our home is in Borpeta, Nepali Bosti in Borpeta district. My brother was a driver and he drove oil tanker. On 16/8/2013, I came with my brother in his oil tanker from Namru. After loading chemical in the tanker, we started off for Kolkata. 3 persons boarded our vehicle from near an oil depot in Namru to go to Sibsagar. Among them, Naresh Das, Bijoy Sonar had been known to my brother Jayanta since before. We started our journey at 8 p.m. We took dinner on the way. My brother Jayanta was driving the vehicle. I was sitting to his left. Those 3 persons sat behind Jayanta. Among them, one was sleeping, Bijoy, and Naresh were sitting with Jayanta. I was looking outside through the window of the vehicle, but previously he stated he was also sleeping. At about 1 o'clock at night, I heard Jayanta shouting "Ma," and the vehicle came to a halt. As I turned towards him instantaneously, I saw Jayanta bending towards one side in a senseless state. I saw a small knife in the hand of accused Naresh. Accused Naresh, accused Bijoy, and the third person were trying to get down from the vehicle. I grabbed the third person. Accused Bijoy hit me on my left leg with an iron lever. As a result, I released the third person instantaneously. These 3 persons got down from the truck and fled the scene. Accused Bijoy and Naresh stabbed Jayanta to death. Incident took place in Chariagaon bypass on National Highway 37. I rang up and called Lakhinder, a driver who is known to me. He called an ambulance and we took Jayanta to JMCH. There the doctor informed us that Jayanta was no more. So here he has stated that he called up. And this Lakhinder was also a driver. And he may have enmity with Bijoy because Bijoy was earlier working with Lakhinder, as per Lakhinder's evidence also, Lordship. Whether those are 3 persons, these are 3 persons, that is also, Lakhinder had already stated. Because Jayanta was working with him earlier. And Bijoy was also working with Lakhinder in his private vehicle, and Jayanta was working with him in previously.
Previous enmity. Did he say this in 313 when Lakhindra's evidence was put to him?
Yes, Lord. He said, I have not committed any crime as alleged. The witness has falsely deposed against me.
Not even in 330.
তাৰোপৰি লক্ষিন্দৰে আহি নিজেই কৈছে আমি দিছে আৰু নিউ এভিডেন্স
Oh. 164 to put for you, Leona, compared with him.
কাৰণ মেজিষ্ট্ৰেটক এক্সামিন কৰিছে ন আয়োগ এক্সামিন কৰিছে
Take the risk of stopping his vehicle and look into it. Tell
Because-
me. On a highway, something on track is like this. See the sketch map.
Yes. Decline position.
If there is this is a dangerous place. The place itself is dangerous. And he said also, PW1 in the, maybe he was informed by somebody, he is from Borpeta, but he said in the FIR itself.
Who is possibly PW.
I came to know that this incident of killing had taken place in Sarigaon bypass. So this kind of things are there. Yes.
Lordship, my humble submission would be, Lordship, the entire prosecution
Madam,
case,
Bora, a bit louder.
Lordship, entire prosecution case is based on,
Mike.
mic is on, Lordship. The entire prosecution case is based on direct evidence as well as circumstantial evidence and the theory of last seen together, along coupled with oral dying declaration, Lordship. And to that extent, Lordship, I'd like to rely
upon the testimony of
Anything
the
about oral lying declaration?
lordship, if it is found to be voluntary, if it is found in a,
Or I think if he's fit or not.
at that time he was conscious, he has rang up his friend, that is PW4, to,
Conscious and
yes.
if he survives, then it is not dying declaration. But he has
Thereafter
not
he died,
survived.
lordship.
He has died.
Subsequently
He died.
Yes, lordship.
So it is an exception to hearsay evidence.
Lordship. Otherwise, lordship,
And principle is that nobody before going to heaven
will
will
tell
say a lie
lie, lordship.
and implicate
Yes, lordship. And lordship,
a
once,
wrong person.
yes, and once the prosecution has established. The
Whether this
prosecution
can be admitted.
can be admitted if it is found to be voluntary, truthful, and at a good state of mind, lordship, because he was conscious at that moment. That has been well proved by the prosecution witnesses, as is PW 2, 3, and 4, lordship. And lordship, one more thing, where if
How far was the house of PW4 from the place of incident?
lordship,
Okay,
just
to that
nearby,
extent, making the call, you
yes,
can infer that he was conscious, make a call.
164 is clear. One statement is, as I turned towards him instantaneously, I saw Jayanta bending towards one side in a senseless state. This is his 164.
there might have some discrepancies, exaggeration, and disembellishment, but
Base
this
80.
is not they cannot be discarded, the prosecution case, because the core issue is still remain unchallenged that the two accused persons, the present appellant along with Nareshwar, has killed the deceased, and the PW2 has got injured, and he is the eyewitness, lordship. And at this stage, lordship, the injured eyewitness person is kept in a higher pedestal than the other person or the other witnesses, lordship. And once it is admitted fact that the present accused and the other accused, co-accused, who is declared as absconder, they were last seen together with the deceased, and that is admitted fact that remains unchallenged. And lordship, if once the prosecution case establishes the fact that the theory of last seen together, and then the onus lies on the accused person, and section 106 of Evidence Act will come into play, lordship, because he owes an explanation as to how he was departed from the deceased after the incident. And he has to also give an explanation, reasonable explanation, how and when, who has caused the death of the
Whether
deceased.
106 should come here.
Lordship, because if certain facts is within the knowledge of
No,
a
there
person,
are
then
many
he has to
persons.
explain to that extent, lordship. He has to give a
Already
plausible explanation.
PW2 was there.
Yes, lordship.
So 106,
Because it's an admitted fact, at that relevant point of time, he was present, lordship. Then he also owes an explanation as to how the occurrence took place. And once, lordship, if he fails to give a plausible explanation, then thereafter he absconds, lordship. Then motive is very obvious. And lordship, to that regard, I'd like to place one judgment. This Ram Gopal versus State of Madhya Pradesh, 2023, 5 SCC 534, I have given to my honorable.
shouldn't be very
Lordship,
likely, isn't it?
para 5, 6, 7, 8, and 9 would be relevant. When we come to paragraph 6, lordship, of the judgment.
Then the last seen theory, together theory comes into play. Here, the last scene was seen by one person,
Well, lordship,
right?
yes.
And the assault was
Yes.
also seen by him.
Yes, lordship.
So this is not a case of
purely,
Finding the diseased,
yes,
Dr. Sam, he was already there.
yes, Lordship,
All three were there.
Yes.
The accused, the
injured
injured,
eyewitness.
and the diseased.
Yes,
Those were there. Last seen together theory, I don't think it will be directly applicable.
Lordship. Otherwise, circumstantial
You
evidence.
see all the cases,
Yes,
last seen together theory come into play when the disease and the accused
Lordship,
were seen in the company of each other.
Lordship,
Then thereafter,
yes,
the disappearance of the diseased and body is found somewhere. Then the time gap
Lordship.
should be very less. So that is purely a case of circumstantial evidence. Then I think last seen together theory comes into play.
Sense of direct evidence.
That will be one link.
It gives an additional link to the chain of circumstantial evidence which forms against the accused person.
But here the leaving the company
Yes,
of the disease
Because
was
they have-
seen by PW2.
yes, and they have
So it-
responded, yes.
I don't
Otherwise,
think this.
Lordship, may not be relevant, Lordship.
Parents এটা draw কৰিব পৰা যায় guilty mind আছিল সেইকাৰণে সি যদি কৰাই নাছিলে তেতিয়াও crime and post
This is my humble submission before Lordship.
Any other?
There is direct eyewitness is there, Lordship. He's the injured. This person is much more having weightage than the other
His
witness.
status higher. 164 statement, you have not
But,
contradicted.
but Lordship, there
Core is
is
there, core is there that
that
assault was made.
assault was there. That is not remain unchallenged, Lordship.
But sword was without blood, Lordship.
Have you seen the size of the sword?
PW4 also, Lordship.
Have you seen the size of the sword? I have seen it. That was not the weapon of assault.
But then,
See the size.
Lordship.
Big one. Very big.
Then, Lordship.
And it is, when seized, it is no blood stain. That was not the weapon of assault.
Yes. But PW4, Lordship, page 17.
I have seen it.
According to him, it is the sword.
He was lying beneath the
Yes.
track. I have seen.
And regarding the injury, how grave that was, we succumbed to the death. On the left side of the stomach of deceased, I noticed one injury. All the inner part of stomach had emerged out from the wounds. So such a situation, the person calling another person, and that too not mentioning in the Ejahar. In 164 discrepancies that the informant had called up, whom he don't even know. Non-examination of the phone calls, etc., Lordship. This is perhaps is not those points
Two things.
in favor of the accused.
Two things. The informant was also injured. Medical report says he has
Exonerate.
but he was taken for treatment. The disease was also taken for treatment. They were not together. They were not together. In the middle of the night, 2:30 AM, it was respondent number 4, PW4, who had attended the disease. I think his testimony is one injury in the stomach of disease. That is there. Why he should describe all this? This is for doctor to decide.
No, but if such a, whether actually the calls were made or those are the person who were involved with the brother, that is another
That is
circumstance. which
defect in the
Investigation that does not
Investigation,
discard the court
that should not-
prosecution case.
That oral testimony, what I want, Lordship. That
Right.
oral testimony, Lordship, oral evidence. Because if he was immediately become senseless, Then how could he inform the PW 3 and 4 that these two,
Who said senseless?
that brother 164?
You are going to 164 time and again. Why didn't you brought it? Court cannot use. What is 162 or 164? That is not substantive evidence. It is for the purpose of corroboration or contradictions.
But
Now you have not brought that contradiction.
Jahar is also silent about all those
It's not
things.
an encyclopedia.
Both you are referring which are not substantive evidence. You are referring to FIR and the previous statement. Those were to be put strictly to those prosecution witnesses. FIR to PW2, his 164 statement also to PW2. Contradiction. If contradiction is required to be brought on record,
And the injury is also if PW2 is evidence that he was sitting out backside, but the injury is from the front lordship. That is.
had it been, it would have been more diluted. Had you not answered everything in your 330.
If he said only, I don't know that much to do, but here he had given some explanation.
Things could have been diluted. But you said,
Admitted
I was
the
present
present.
at that relevant.
I was
Yes.
present
Did the crime.
in the tanker at that time.
The sleeping part is corroborated by PWP.
On hearing UN cry from Jayanta Das, I woke up. I saw fighting between Naresh or Jayanta. Brother of Jayanta, namely Kumud Das, got company of Naresh Das. I played away. You said I played away. You were the handyman. Your driver was assaulted.
No, he was not regular handyman as per PW4. As per PW4, I'm reading lordship.
Are you denying this, all this stuff? Nobody, nowhere you said. From Kerala to Borpeta, Borpeta to Namrup, Namrup to Sipsagar, Sipsagar to the place of incident. You are the handyman. Your duty was to rescue your driver. Instead, you fled away. That is your version. Then you ran to which place? Naresh Das. Then from Naresh Das' house, you were arrested. What does it indicate? You were handyman, you were supposed to rescue your driver. You should have called instead of calling his friend. And this man, he said correctly, it is to be believed because he is from Borpeta. He is not a driver. He is not a driver. He said also that maybe he has come with his brother for a visit. That is what has emerged from this.
He is
He
supposed to go to Calcutta with his brother.
The Borpeta.
No, they are, they will,
Borpeta, he boarded his
yes.
truck Borpeta.
Then Namrup to Kolkata, they are.
Namrup, Sipsagar, Dhaba, then that place,
Sorry,
and they were supposed to go to Calcutta.
yes.
Maybe he would again drop down at Borpeta. Ms. B. Sharma, learned amicus. You appearing for the accused appellant, and MS S.H. Vora, learned additional public prosecutor for the respondent state. Arguments are heard. Judgment is reserved. মানে what explain করলে
Lordship.
out of the same judgment.
Out of the same judgment. Allow for them.
Song itu song. Itu song. It's
Same paper. Same paper, my lord, the same judgment. The accused are convicted, my lord, on the basis of the circumstantial evidence and the also applying the principle of last seen theory. There is no direct evidence, no eyewitness. So, my lord, the lordship will, the paper book. The FIR was lodged, my lord, alleging that
1 minute. One is from jail. One is jail living.
the
Item number 6, ma'am.
5 and 6. I am for the 5, my lord, I think 6.
Conviction
Only life imprisonment, my
Live
lord.
imprisonment, 302.
Life in
302.
302. Under 3 sections, the charge was framed. 364, 302, and 379. And so
Conviction is
379, no ingredients were found.
364 also.
302 and 360.
364 and 360. $79. Three charges.
Yes, my lord. SARS. Possible 6 SARS.
364 with the
Yes, madam.
with the aid of 334,
Yes,
302 with the aid of 34,
yes.
and 379.
379. the
379 acquitted,
Acquitted,
364 convicted,
con-
302
convicted,
convicted.
convicted. On the basis of circumstantial evidence, my lord.
Was firstly there.
That's
And sentencing,
sentencing life imprisonment under section 302 and
leniently treated under section 364 IPC.
yes, 5 years.
5 years.
Rigorous imprisonment,
Rigorous.
rigorous imprisonment. Rigorous.
No award under 357A. Yes.
The lordship,
Yes.
how to see that Azhar, lordship, the paper book page number 4, FIR. FIR, with due respect, I submitted
A bit
around,
louder, Mr. Upadhyay.
my lord,
Bring the mic. Near you.
yes.
Hey, mic is simple. ঠিক করবো রে।
How? 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 Kind of paper book, FIR. So I read that. With due respect, I beg to submit that around 8 AM on 7/1/14, while my driver, whose name and address are mentioned below, was waiting at the taxi stand at Gogamukh Gerua Post along with Maruti van bearing registration number such and such, which is registered in the name of my father. Two youth who are familiar to the driver wanted to hire the car for going to Dhokua Khana. When my driver told me about it, I gave him permission to go there. Around 8 PM, driver informed me over phone that they had crossed the Champara bridge at Gilamara, and thereafter I was not able to establish any communication with him. Since I did not get any information, even after the night, I went to the house of driver in morning, but since I did not get any information about him at his house, I come back and went to the police station, informed the police that driver had not returned home along with my vehicle. Meanwhile, learning that a dead body was lying at the place within the jurisdiction of Gilamara police station, I went there and identified the dead body. The said two unidentified youth, in furtherance of their previously hatched plan, took the vehicle on hire, killed the driver, and lifted the vehicle. I therefore, this is the FIR. Yeah, my lord. The list of the FIR is that the vehicle was taken on hire by the two unidentified youth to go to Dhokua Khana from Gogamukh. And further, my lord, he said that he was in contact. The first informant was in contact till Champaran bridge. I gave him permission to go there. At around driver informed me over phone they had crossed Champaran bridge. Till Champaran bridge, the first informant was in contact with his driver, and thereafter he was not in contact. Since I did not get information even after the night. My lord. Yeah, my lord. Thereafter, my lord, this FIR was registered. An investigation was made by the police. Case was registered under this section 364, 302, 379. And your honor will see and the charge sheet was filed, my lord, after investigation. As many as 15 witnesses were examined, my lord. The main, my lord, here, the witness number, my lord, witness.
Yes.
11 year lordship,
Hmm?
PW 11, who said that he had seen them together when the vehicle was hired. 11. Page number 27. Metal with he said "27, my lord." He said, Rajesh Murthy, I recognize the accused present in the dock, but did not know their name. Manoj Kumar was the informant to me. Jogesh Sutia was known to me. It was about 2 years back. The two accused had taken the car of Manoj Kumar, and then driver of the car was there. At the time, my car was also parked there. I was having the key. Later, I got to know that the driver was. That means that the PW 11 who claimed that he has seen together the accused person at the parking place, and he was there. His vehicle was also parked there. This is only the minor the accused two accused persons who were seen together last time, and this he claimed that he had seen. But in the cross examination, he said, I don't know, I do not I do not know the names of the accused as I only saw them on that day. It is not a fact that I have not seen them who had taken the car. The other witness, my lord, the PW1, my lord, is the first informant. PW1 is the first informant. What he stated in the FR, same in here is also reiterated here. My lord, the car vehicle which was recovered, which was found in abandoned condition, he stated that the car was found. PW1 said that the car was found. My vehicle was found at Tekaraguri on the following day of recovery of the body. And the PW1 said,
Informant?
first informant, PW1. He said, Exhibit 1 is there by Lodney. Exhibit 1 is my signature. I have marked event. The incident took place on 8/1/24. My driver went out along with my marked event. Later, he informed me over the phone that he had gone to Dhokwa Khana to drop the 2 persons known to him. But since he did not return, I rang him up. Then driver Jogeshwar Sutia told me that he had crossed the Gilamara Samparan bridge, but the driver did not return along with the vehicle thereafter. The following morning, I went to the house of the driver. The member of the family of the driver told me that driver had not returned home. Then I went to Gogamukh police station and lost an Azhar Exhibit 1 there. While I was in PS, police from Gilamara PS informed me to that PS that they had found a dead body. Then I, along with the police, went to the Gilamara. One is my signature. The post-mortem examination on the dead body was held in Lakshmipur Civil Hospital. Thereafter, dead body was brought home and was cremated. My vehicle was found at Tekaraguri on the following day of the recovery of dead body. After recovering the vehicle, the police handed it over to me on Zimma. Exhibit 3 is the Zimma Nama. Exhibit 3 is my signature. Therein, in Gogamukh period, accused Mintu Setia stated before the police that accused Bidul Kolita had killed the Jogeshwar Setia at the time I was present in Gogamukh police station. It is not a fact that accused in cross-examination, Mintu Setia did not state that accused Bidul Kolita had killed the Jogeshwar. This is the statement of PW1. The PW2, my lord, I saw PW2, my lord, Atul Pegu. He said, I am the VTP secretary of village of Abhayapur. Seeing a Maruti van keeping kept parked on the road of, that means PW2 showed up that van which was missing. I informed the police of the Manoj Kumar arrived at the place of occurrence. The vehicle was sick and vehicle. He just informed. The PW2 informed that he saw the vehicle on the road, in the field. He saw the vehicle, informed the police of it. PW2, my lord. The PW3, my lord.
Yes, PW3.
So PW3, my lord, he said he saw the dead body was lying near a culvert. He said, I know the informant, I do not know the accused. The incident took place about 2 years ago. Sonai Sutia used to drive the Maruti. Sonai Sutia is the victim, my lord. Drive a Maruti van. Someone hired the said vehicle. Sonai Sutia did not return thereafter. His dead body was lying near a culvert. I went to see the dead body. Police held inquest on the dead body. I put my signature in the inquest. Exhibit 2 is the inquest report. Exhibit 2 is my signature. I do not know who hired the vehicle. I do not know how Sunai Sutia died. This is cross-examination, not a material witness. And now the PW4, my lord. PW4 is a Tankeshwar Gogoi. He said the incident took place in 2000. Gogamukh Padma Saikia came to my house in the morning, informed me that a dead body was lying near the Pakka bridge in between the Laukut and Singia. Then the Gaubura and I went to that place where the dead body was lying on my motorcycle. A crowd of the people gathered there. The dead body was not identified. I informed the OC, Gilamara police station, over phone and about the incident. Police came to the place of occurrence immediately, seeing cut injury caused with a dao on the neck. The police searched the dao. One Khumti dao was recovered. Police seized the said dao. Exhibit 4 is the seizure list. Exhibit 4.1 is my signature. Thereon later the family member of the deceased identified the body. That means, my lord, nearby the dead body, the Khumti dao was said a Khamti, not Khumti, Khamti dao was recovered. And exhibit 4 is the seizure list, my lord. And 4.1 is the signature. That means actually, in fact, the PW4 is a seizure witness. Seizure witness. And 5. Exhibit 5 is also seizure witness. 5. Srimati Purprabha Saikia. She is also seizure witness in the exhibit 4. Seizure list, my signature. 5 is also my seizure witness. And 6, or she will see 6. My lord, PW6, my lord, the said that I am the BDP secretary of village number 1, Singia. The incident took place in the month of January 2014. Children of the village informed me that a dead body of man was lying near the bridge at Singia. That took neck of the body was in half spilled state. Then I sent Dipankar Gogoi to inform the Gaubura Padma Saikia and BDP secretary Tankeshwar Gogoi. Both the Gaubura and secretary came to my house. Then I, along with those 2 persons, went to the place of occurrence. We saw a dead body of a man lying there. There was an injury on the neck. A Khamti dao was lying near it. And Tankeshwar Gogoi informed the police of it. Police came to the place of occurrence. On the basis of her statement, the dao was seized. Exhibit 4 is the seizure list. Exhibit 3 is my signature. He is also seizure witness. Exhibit 1 is that dao I have recognized it. PW6 minor, he is also seizure witness. Also not the information seizure. PW7 minor, 1 Khatik Chandra Satya. He is also seizure witness. Not Caesar, not Caesar, what is he said, PW7 minor. I know the accused. Now I also know the informant. This is Jogesh Sotia. Sonai was my younger brother. The incident took place at about 2 years ago. My younger brother was working as a driver of the Maruti van belonging to Joy Chandra Kaman. One day when the said vehicle was hired for a trip to Dhokua, my younger brother went there, but he did not come back from Dhokua Khana. Following day, he went to Gogamukh taxi stand and made an inquiry to the effect. Boys who were present at the taxi stand, 12 of them accused Mintu Setia along with another boy hired the said vehicle to go to Dhokua Khana. We informed the police station of it. And 1-2 hours later, we got the information from the police that a dead body was lying by the side of road and leads to Laupot. I accompanied by the owner of the vehicle and boys who were present at the taxi stand went to that place. I saw the dead body of my younger brother lying there. I identified the dead body, exhibit 2 in the inquest report with exhibit 2-3 is my signature. I put my signature in cross-examination. He said, I put my signature 2-3 in exhibit 2 at the places where the dead body was lying. It is not a fact that nobody from taxi stand said that the accused Mintu Setia along with another boy had hired a said vehicle to go to Dhokua Khana. That means the PW7, who is the brother of the victim, and he collected the information that the accused person had hired the vehicle. He collected the information and gave the information to the police. He said, the PW7. Eight minor. He identified a dead body. And the incident took place in 2014. Sonai Sotia. Sonai Sotia of village was lying dead on the road at Gilamara. I accompanied my other blazer, went to the Gilamara. We were informed that the dead body of Sonai had been taken to the police station. I went to the police station. I met the Sonai elder brother, Patik Sutia, at the police station. Patik Sutia identified a dead body at the police station, and then I was present at the police station. He, with Patik Sutia, I do not know how Sonai died. Not a material witness. We just identified the dead body. PW8 identified the dead body, madam. 9 said PW9 Lakeshwar Kaman. He said, PW9 minor. He said, I know the accused Mintu Sutia and Bidul Kolita present in the dock. Manoj Kaman, the informant, is my elder brother. It was about 2 years back. Bidul and Mintu took the car of Manoj on rent, saying they will go to Dhokua. The driver of the vehicle was Jogeshwar Sutia. I was present when they had taken the car on rent. He said, he claimed that he was present when he had taken the car on rent. The car did not come back even after it was night. Next morning, I was informed by Gogamukh police that a person was lying dead near the Singhiya. Then Manoj had went and found the dead body of the Jogeshwar. The car was not found. The car was found after 2 days near Thapua Khana. The dead body was taken to Lakhimpur and I have not seen it. My brother Manoj told me it was the dead body of Jogeshwar. Police has questioned me because he said I did not tell the name of the accused when the police has questioned me. Well, very important because I did not tell the name of the accused when the police had questioned me. It is not a fact that I have not seen who had taken the car. Accused has taken the car at 2 o'clock. It is not a fact that accused has not taken the car. But in the cross-examination of examination chief, he said, my lord,
So what circumstances should have been
my
proved?
lord, circumstances, your
What
lordship.
circumstances
Yes,
should have been
circumstances,
proved?
The last in that theory, that principle of last in here applied here, my lord. And circumstantial evidence also applied. But
Whether last scene is there or not first.
no, last in only the PW 11 said. PW 11, who later also identified in test identification rate was also here. But was later after 1.5 months later. After 1.5 months later, that
When they were arrested, when the
after-
accused were
after
arrested,
arrest, they were
please,
in
please,
Jail Hazo.
date.
Yes.
The arrest or in the paper book, it is not there. We have found out from the records, my lord. Bidul Kolita was arrested on 13/1. 2000 Bidul Kolita on 13/1, 2014.
2000,
And 14.
2014.
And Mintu Chutia on 16/1.
Midul Chutia,
Mintu Chutia,
Mintu Chutia on
16/1.
16/1. Okay, TIP
On 28/2. Sorry, madam, 25/2.
25 to 25 to
25/2.
25 to
more than a month.
More than a month.
more than months.
TIP was done properly. That is not the doubt. The magistrate has done it properly, undertaking necessary precaution. But so far as the delay is concerned, delay is more than a month, about 40 days from the date of arrest.
From the data.
So in the meantime, their production before the court also had happened.
Yes. Happened. According to
This is enough.
I did not.
Or why this is not enough?
Yes, my lord. So far 9 is concerned, your lordship, in cross-examination, he said, I did not tell the name of the accused when the police had questioned me. In the cross-examination, he said, but he did not tell the name. He is not reliable. Only he stated before the court. But before the police, he did not tell. So it is that his development, he developed his statement before the court and he admitted he did not tell the name. So 9 is not reliable, my lord. So far 11 is concerned, my lord, here your lordship will say that only on the basis of whether the last scene together we can be applied only on the basis of this statement. But he is also, I do not know the name of the accused. In 11 said that I recognize the accused in the dog, but I do not know the name. Manoj Kaman, the informant, is known to me. And Jogeshwar Sutia was also known to me. Jogeshwar is the victim. Jogeshwar Sutia is the victim also known to me. It was about 2 years back, the accused had taken the car of Manoj Kaman on them. The driver of the car was there. At the time, the car was also parked there. I was having tea. Later, I got to know that driver was killed. Police has questioned me. But it is, my lord, it is parking place of car. So there might be some other person also. How only the PW 11 show? There must be some other driver also. It is a parking place. This-
Question is about applying the TIP
Yes.
evidence
Yes,
into the facts of the case.
yes,
TIP is evidently carried out after 40 days,
yes,
right? Then 9 and 10, they were the only person who claimed that they had seen the accused hiring the car. The incident happened on 7 January 2014.
yes,
Their testimonies were recorded in November 2016. They were not confronted with the TIP record to make such on the basis of these documents. Others have not identified you. The PW 9 and PW 10, they had identified you. That last seen together might come on that context, in that context. And also the value to be attached to the TIP. Whether magistrate has exhibited the TIP record, whether these two can be linked or not.
yes,
Make submission on that point.
yes,
Issue is very simple now.
yes,
TIP was done. PW 9 and PW 10, as per the TIP chart, they had identified. And identical persons were paraded
very,
and intermixed
yes,
later on. Then both one by one had identified the two appellants, right?
right,
That is the record in the TIP speaks. And that is exhibited by the magistrate, SDJM,
yes, yes,
right?
yes.
And the testimony of PW 9 and PW 10 before the court. And evidently they were not shown the TIP record, right? They were not questioned by neither by the prosecution nor by the defense. And their testimony was recorded after more than 2.5 years
Yes,
from the date of their arrest and from the date of TIP. Now, how can this magistrate evidence and the document he has exhibited as regards TIP can be linked to PW 9 and 10? And whether this testimony of PW 9 and 10 is sufficient to bring home the charge of guilt against the accused. Yes, please. Things are narrowed down.
yes, sir. I have understood,
Yes.
I have understood.
I have my submissions. I have my. Because Lordship will have to see the timeline, madam.
That is why we have specifically
Yes,
pointed out
timeline.
TIP was done after 40 days.
Not only that, my lord, even the timeline of the incident.
Then whatever.
Yes.
But incident is there, but only issue is that whether these 9 and 10, only the entire case is based on their testimony. They claim that they had seen the two accused hiring the car at the taxi stand. That is one point. But TIP was held evidently after 40 days and magistrate exhibited it. But these two witnesses were not confronted with the TIP record. So the point that has emerged otherwise, if that is that TIP exhibited by the magistrate cannot be linked, then that the point emerges is that they had identified the accused for the first time in the court.
Yes.
Right? In the absence of the TIP. So this is the point we are
Yes.
seeking answer.
The FIR says that at 8 a.m. in the morning, 2 persons known to the driver has taken the vehicle on hire. And from 8 a.m. till 8 p.m. there is no contact. Now, if your lordship turns to the PW1 mallet at page 17.
Yes.
The incident took place in 2014. So-and-so came to my house in the morning and informed me that a dead body was lying near the Pakka Bridge so-and-so. Then the Gaubura and I, sorry, Malad, I'm reading PW4, Malad, I'm extremely sorry. PW1 at 11, Malad. Exhibit 1 is the Ejahar lodged by me. 1-1 is my signature. I have a Maruti van. The incident took place on 8/1/2014. Now, this is important, Malad.
Yes.
This is important. My driver went out along with my Maruti van. Later, he informed me that he had gone to Dhokwa to drop 2 persons known to him. Lordship will mark. Why I am putting emphasis on this is for the charge under 364 Malad. So it is not, he was not taken forcefully, my lord. It's taken on hire by 2 persons known to him. Next sentence. But since then he did not return, I rang him up. Then driver so-and-so told me that he had crossed Kilamara Champara Bridge, but the driver did not return along with so-and-so. So at 8 p.m., my lord, he was coming back from Dhokwa after dropping these persons. Now, what the TIP and PW 9 and 11, 9 and 10 has said, they have identified the appellants here in my lord at 8 a.m. when the vehicle was taken on hire.
Where is the evidence of returning from Dhokwa?
This is the evidence, my lord. Later, he informed me over phone that he had gone to Dhokwa
He had crossed Ghilamara Sampara Bridge.
Now, my lord, that is why I have taken out.
His onward journey. It was his
Exactly,
onward journey or
exactly.
backward?
I'm coming to that. Now, lordship will have to see the distance vis-a-vis the time taken. I have taken the effort of taking the distances from Google Maps, my lord. So the distance from Gogamukh, where the taxi was taken, to Ghilamara Champara village, bridge, my lord, is hardly 18 kilometers. So for 18 kilometers, definitely he will not take 12 hours, my lord. If your lordship permits, my lord, I had taken out the distance from Google Maps, my lord. The three, 4 points are important. One is, my lord, the point of Gogamukh, where the vehicle is taken on hire. Next is Dhokwa. Then is Champara Bridge. Then it is Thekeraguri, where the dead body is found. and Hingia is where the vehicle is recovered. Thekeraguri vehicle. No, sorry, my lord. Thekeraguri, the vehicle is recovered. Hingia, I think the dead body is recovered.
No, that is only assumption.
My lord. My lord, the burden is on the prosecution to prove. My lord, Lordship reads it again, third sentence. Later, he informed me over phone that he had gone to Dhokwakhana to drop. I have read the vernacular also, my lord.
No, your submission that he was returning from Dhokwakhana,
Exactly.
that is your assumption.
Not my assumption. I am saying from PW1, my lord.
Hmm.
PW1 says, later he informed me over phone that he had gone to Dhokwakhana. He is not going towards Dhokwakhana. I have read the vernacular, my lord. I have cross-checked since this is a translation. To drop two persons known to him. But since then this is something different. But since he did not return, I rang him up. Now, this time of calling is not coming out from the evidence. It is from the Azahar, my lord. That he rang up at 8 p.m. কি কৈছে অসমীয়াত? থৈ আহি আছিল ন? Now, my lord, lordship will kindly come to page
No,
88.
after perusing this evidence of PW1, can it be said that he was returning from Dhokwakhana?
That is
after
my
dropping
humble
them?
submission, my lord. That is my humble submission, because then the prosecution
No,
will have to explain.
Your submission is based on assumption.
No, my lord. The prosecution will have to prove, have to give, explain as to what was being done, my lord, during these 12 hours. If 8 a.m. the vehicle is taken on hire, at 8 p.m. in the evening, I have reached just 18 kilometers, my lord. Where is the explanation? From the side of the prosecution, my burden is on the prosecution to prove. Then why I am drawing your lordship's attention to the post-mortem, my lord. Post-mortem is done next day, 8th. The post-mortem is done at 3 p.m. and time of death is said to be 20 hours. So if we back calculate, it is somewhere around 7 p.m. in the evening. Lordship comes to page 88.
Yes.
Examination time, my lord, 3 p.m. 8:01. Lordship has got it. Then page 91. In my opinion, the cause of death is shock and hemorrhage as a result of lethal injuries. The time since death is approximately 20 hours. Twenty hours only. 7 p.m.
That's why we are asking both of you how far this TIP And this last seen theory can be relied upon.
Exactly, madam. Madam, to rely upon the TIP, let us, madam, for a moment, let us assume that yes, he had seen. Let us for a moment, madam, assume that TIP was validly done. I admit that I had taken up. Madam, taking the vehicle on hire, will it establish the killing of the deceased by the accused, madam? Because the lordship knows, madam, last seen theory, there has to be some
After
close
going
proximity.
through the entire evidence on record laid by the prosecution, what we are thinking is that these are the only two things which requires establishment by the prosecution. If this is not tenable in law, the links fails. That is why we concentrated on these two issues.
Exactly, madam. So if we go to the
If that links fail,
even other,
every link fails.
otherwise also the links fail, my lord, because
That
the
is why
time gap, my lord.
the point of law we have put before you is that apparently the procedure required to be done in the TIP was done,
Done.
right? He said, magistrate said
Yes.
in the TIP seat, I intermixed and position changed when the second person was brought. Yes. These are apparently procedure was formalities were followed.
Followed.
And he exhibited the TIP sheet. Question is that these two persons, PW9 and PW10, when their evidence was recorded, that TIP thing was not brought before them.
It was not on record, my lord, because it
No.
is PW15 who has brought it. So
Not
there
a,
was
not a single question was asked about the TIP.
because at that point in time, my lord,
That
TIP
is
was
not the law,
proved,
Mr. Teka.
my lord. TIP was not proved, my lord, till
Okay.
that point of time.
Okay.
My lord, on TIP, my lord. Exactly, my lord. They should have proved the TIP ought to have been proved by those
That
witnesses,
is
my lord.
not substantive piece of evidence.
Exactly. My lord, lordship on that.
Otherwise, missing that thing in their testimony that amounts to these two witnesses identifying the accused for the first time in court.
I'm coming to that. I'm coming to that. My lord. My lord, on that point, my lord, I'd like to rely on a judgment, my lord. 2022 Live Law SC 510, my lord. Manoj and others versus State of Madhya Pradesh.
Already reported in SCC.
SCC it is reported, my lord. I don't have the, I have it here, my lord. Paragraph 100 of this particular judgment. It affects the credibility. The Supreme Court says that there is no fixed time, but it has to be produced because the moment the accused persons are brought before the court, the witnesses see them, my lord. It affects their memory. That is what the apex court is saying, man.
That says that it should be at the earliest.
It
There
should be at
not be all these productions, police remand.
Exactly.
What is the reason for delaying the TIP for 1 month or 30 days, 40
Maybe
days, 2
more,
months?
maybe more.
These accused persons were produced before the court
Many times.
many times in between. That is discussed.
And that is
Is it not?
that is there, man. That is one limb of the argument that TIP is vitiated. And I am going a step further, my lord, if with your lordship's permission, that even if he has identified what has been proved is the taking of the vehicle on hire, my lord. Now the the body is found at least 12 hours, minimum 12 hours. Even if you go by the medical report, my lord, the time of death is 12 hours. And on the last seen theory, my lord, there is no close proximity. There is nothing on record that shows the prosecution has not proved that there was no chance of anyone else coming in contact with the deceased, my lord. So on that point, my lord, I'll rely on a judgment from our High Court, my lord, that Anjan Sharma's case, my lord, 2017, 14 SCC 359. My learned friend, Mr. Upadhyay, my lord, he has a printouts, 2 copies. 2014, 1714 SCC 359. Paragraph 14, my lord. Also paragraph 11, so far as the 364 is concerned also, well, I'll rely on paragraph 11 also. Descending. For the charge of 364 para 11, my lord. Then 12 also for the part of non-explanation in 313, because that is a ground of conviction. Then 14, my lord. Admittedly, Lordship has got it. Admittedly, this is a case of circumstantial evidence. Factors to be taken into account in adjudication of cases of circumstantial evidence laid down by this court are that the circumstances from which the conclusion of guilt is to be drawn should be fully established. The circumstances concerned must or should and not may be established. The facts so established should be consistent only with the
Becca,
My
this is quoted from the judgment of
Yes,
Shabda
yes.
Ardot petition.
Yes, my lord.
So where is the ratio of this case?
This case,
Yes.
my lord, here what had happened, my lord, the
No, you point out the ratio of this case. Who, in which paragraph it has been discussed?
23 is the final, my lord, conclusion, my lord.
23.
It is clear from the above that in a case where the other links have been satisfactorily made out and the circumstances point to the guilt of the accused, the circumstance of last seen together and absence of explanation would provide an additional link which completes the chain. In the absence of proof of other circumstances, the only circumstance of last seen together and absence of satisfactory explanation cannot be made the basis of conviction. And this is what has exactly been done in the present case. In this particular case, my lord, I think the last seen together was at 9 p.m. at night, and body was recovered on the subsequent day or 2 days thereafter. And the doctor had opined that death had taken place on within 48 hours. There, the apex court has held that no, the time is not proximate. So here, my lord, my grounds are: number one, the last seen theory will not come because of the difference in time. Of course, the TIP cannot be relied upon because TIP has taken place after 45 days. In Manoj, I'll be relying upon Manoj Kumar paragraph 100 that it has to be done within a reasonable period. Paragraph 100 key question, it does not vitiate, my lord. It says that does not vitiate, but the credibility of the witness. We just read it out. 99 and 100, my lord. The main argument against the TIP proceedings was that it was held after an inordinate delay. The appellants were arrested on 22/6/2011 and remained in custody till 36. It was urged that no attempt was made to involve the magistrate to have their TIPs either at that time or thereafter. And the TIP was held only on 14/7, madam. That was within a month. Exhibit so-and-so, the TIP relating to Rahul and so-and-so records the names of, so this may not be relevant, my lord. 100, a popular and widely used method of accused identification by witness in criminal trials is the identification parade. TIP procedures are used where witnesses who claim to have seen the accused at or about the time of occurrence to identify such accused from the midst of other individuals who bear physical attributes similar to them without any aid or other source. TIPs are meant to test witness veracity and their capability of identify unknown persons. TIP should normally be conducted at the earliest possible time to eliminate the chance of accused being shown to witnesses before the identification period, which might otherwise affect such witnesses' memory. TIPs are conducted during investigation. However, there is no provision of law enabling an accused to claim it as a matter of right. As held in so-and-so versus so-and-so and so-and-so, this court outlined the utility and weight of a TIP. There is no hard and fast rule that delay or failing failure in holding the TIP ipso facto renders the evidence inadmissible or unacceptable. It, however, affects the credibility and weight attached to the evidence. The first limb of argument is, my lord, that the TIP is bad, could not have been relied upon. And second line of argument is, my lord, even if it is taken as correct, what has been established is the taking of the vehicle on for hire at 8 a.m. Now, the IO who has come before the court to adduce evidence, my lord, he had not conducted the investigation. He was the officer in charge of the police station. The earlier IO had gone, my lord. He had just simply taken the records and adduced evidence.
So even then, whether any question was put to him
Regarding?
regarding this, you have submitted what you have submitted?
No, my lord. If he has not said anything, he says everything from the record, my lord.
Mhm.
He has not done the investigation.
Maybe, but any answer he could have put forward if any question was put to him.
Oh, my lord, he was not cross, my lord. He was declined. Why should I cross him, my lord, if he does not say anything adverse? My lord, the dhow which was recovered was not sent for forensic. The car which was seized was not sent for forensic. The doctor was not shown the weapon. That is this a possible weapon that injury could have been caused by this weapon? And the IO does not say anything, my lord. IO simply says that I was on duty as the OC on that day. SI so-and-so, who was the investigating officer, got transferred. He handed over the case diary of that case to me. Then I myself took the charge of completing the task of investigation. I am reading page 31, my lord. Then 32. On perusal of the case diary, I found that in the course of his investigation, the doctor had drawn this sketch map, so-and-so, so-and-so, so-and-so. Perusing the statements, next paragraph, my lord, I found that it was not necessary to examine any other witness. But he has not independently carried out any investigation. He does not know anything about the case.
No, maybe, but he adduced evidence on the basis of materials available in the
Available
case
on
diary.
record.
Case diary.
Exactly. So case diary, my lord, what has been recovered? The dhow. It is not sent for
No,
forensic.
did you put any question why he did not send the dhow to the forensic science
Why would I
laboratory?
put a question why he has not sent? He has not sent, he has admitted. He himself says, my lord, that he has not sent.
Where?
It is not sent, my lord. Then if it is sent, my lord, where is the forensic report?
No, you could have put a question to him that did you send the dhow to the forensic science
My
laboratory?
lord, it is an admitted position that he has not sent. In the charge sheet, it is there that there was no blood mark found. That is why it was not sent, my lord. Page 96 and 97.
Merely because there was no cross-examination.
Lordship has found, my lord, 97 at the top. Sentence starts at 96 at the bottom. The preceding investigation officer has mentioned that he had seen blood-like substance on the handle of the dhow at the time of its seizure. Lordship has got it. But since no such substance was found stuck on the dhow, it could not be sent to forensic site laboratory, for example. This is part of the charge sheet. My lord. No, the prosecution does not say anything that there was any prior enmity between the parties.
Caesar list state otherwise.
My lord,
Caesar list page number 85,
80,
85,
yes.
stained with blood clot like substance.
Exactly, that is what the charge sheet also says, my lord. Charge sheet also says the prior IO had said that there was blood, but the person who has submitted the charge sheet, he did not find anything, so it was not sent. Page 96, my lord. Lordship comes again to 96. The preceding investigating officer has mentioned that he had seen blood-like substance. This is 85, my lord. Page 85. But since no substance was found, admittedly, my lord, it was not sent. And why it was not sent, the IO has given. Well, I'd like to place reliance on 2007 3 SCC page 755.
Yes.
There, my lord, the time gap was around 2.5 hours. It is on last seen together, my lord. Here, a couple was accused of murdering another couple, my lord. Where one couple had gone on their honeymoon, my lord, and the other couple befriended them and murdered them. That was the case, my lord. Paragraph 29 and 30 are on the facts, my lord, on the evidence of the witnesses. 31 is the analysis. May I read, my lord? Before we analyze the evidence of PW11, Dinesh Adhikari, who was working as a domestic help in the bar and restaurant so-and-so. PW14, so-and-so, who was said to be in the company of A1 and D1 on the evening of so-and-so outside the lounge of the restaurant, and so-and-so Amit Banerjee, who was working as receptionist at hotel so-and-so. We would refer to certain decisions of this court on the point of last seen together. It is a settled rule of criminal jurisprudence, and that suspicion, however grave, cannot be substituted for proof, and the courts shall take utmost precaution in finding an accused guilty only on the basis of circumstantial evidence. This court has applied the above general principle with reference to the principle laid down of last seen together in so-and-so. This is a quotation, my lord. The last seen theory comes into play where the time gap between the point of time when the accused and the deceased were seen last alive and when the deceased is found dead is so small that possibility of any person other than the accused being the author of the crime becomes impossible. It would be difficult in some cases to positively establish that the deceased was last seen with the accused when there is a long gap and possibility of other persons coming in between exists. In the absence of any other positive evidence to conclude that the accused and the deceased were last seen together, it would be hazardous to come to a conclusion of guilt in those cases. Then 32 is another, my lord, same. And from 34 is the finding rendered in that particular case. From the principle laid down by this court, the circumstance of last seen together would normally be taken into consideration for finding the accused guilty of the offense charged with when it is established by the prosecution, but the time gap between the point of time when the accused and the deceased were found together alive and when the deceased was found dead is so small. This is a repetition of the same thing, madam. That possibility of any other person being with the deceased could completely be ruled out. The time gap between the accused person seen in the company of the accused deceased and the detection of the crime would be a material consideration for appreciation of the evidence and placing reliance on it as a circumstance against the accused. But in all cases, it cannot be said that the evidence of last seen together is to be rejected merely because the time gap between the accused persons and the deceased last seen together and the crime coming to light is after or of, it should be of a considerable long duration. There can be no fixed or straitjacket formula for the duration of time gap in this regard, and would depend upon the evidence led by the prosecution to remove the possibility of any other person meeting the deceased in the intervening period. But this is important. That is to say, if the prosecution is able to lead such an evidence that likelihood of any person other than the accused being the author of the crime becomes impossible, then the evidence of circumstance considered as one of the circumstances in the chain of circumstances to prove the guilt against such accused person. Hence, if the prosecution proves that in the light of the facts and circumstances of the case, there was no possibility of any other person meeting or approaching the deceased at the place of incident or before the commission of the crime in the intervening period, the proof of last seen together would be relevant evidence. For instance, if it can be demonstrated by showing that the accused persons were in exclusive possession of the place where the incident occurred or where they were last seen together with the deceased, that there was no possibility of any intrusion to that place by any third party, then a relatively wider time gap would not affect the prosecution case. Of course, this is not applicable here. My lord, what I am submitting merely if I have not offered any explanation in my 313, my lord, that cannot be the sole basis of conviction. The submission of the counsel is recorded in para 37. Lordship has got it. Then 38, man.
What are the circumstances the learned trial court had taken into consideration to reach his finding of guilty?
It starts from para 23.
Basically, what are the main circumstances?
Circumstances is last seen together.
Last thing.
One more aspect, my lord, I'd like to point out, my lord. The lapse in the part of the prosecution. My lord, the vehicle was found at a different place. Dead body is found at a different place. Vehicle, simply it is seized, handed over to the owner, PW1. No forensic, my lord. Whether there was blood inside the vehicle, if I had tried to steal the vehicle, whether my fingerprints were there in the steering wheel, who will prove all these facts?
So far fingerprint is concerned, investigation in the state has not advanced to that extent.
My lord,
That
my lord,
it
my
has
lord,
not
my lord, may I submit one thing?
advanced to that extent. These are defects.
My lord, depending on the case, they carry out detailed investigations. My lord.
It is true.
They carry out. It is
We
not
have
that
seen
they cannot
hardly-
quit.
We have seen in hardly few cases.
Exactly.
We have seen also DNA profiling also in one or two cases.
DNA profiling, my lord, in my respectful submission may not be helpful because I am not disputing that I have not in the case.
No, Mr. Dekar, not in your case.
Oh, my. In general, it is done. my lord.
No, we have seen in some investigation,
It is
DNA
done.
profiling is also done.
Yes, yes.
In some cases, there are flaws in the investigation. Depends.
In
But-
some, my lord,
But so far fingerprinting is concerned, it has not advanced to that extent. That is my general observation.
Lordship is correct, my lord. Even if the vehicle was sent, my lord, they could have found if because
Yes,
the-
it is true. Yes, presence of bloodstains is
Yeah,
there
yeah.
or not, those are basic things which should be recorded.
That should be.
But don't expect fingerprinting.
So Lordship was asking about the findings, but it starts at page 70, my lord, from paragraph 23 onwards.
70.
No, I'm sorry. Yes, from 23, submissions are recorded, my lord. Findings. No, submission. These are all submissions.
It's 6 of this.
32, my lord. My lord, this with utmost respect, my lord, para 32, this will be a perverse finding, my lord. On consideration of the facts and circumstances brought on record, we find that there is ample evidence on record that the accused persons were last in the company of the deceased till 8 p.m. on 7/1/2014. No one says that, my lord. If we come back to PW, because the only person who says about the time is PW1. PW1 says that the driver had told him that I had gone to Dhokwakhana to drop 2 persons. The London District Judge, my lord, places reliance on 106.
Seen paragraph 33.
33. Then 37,
Then
my lord. And 40 is on the 364, my lord. There also, this finding is also in my respect for submission perverse, my lord. Here in this case, on consideration of the materials on record, we find that the accused persons by deceitful means hired the vehicle. Absolutely no evidence on that. And the driver of the vehicle was found soon after the abduction. Hiring is at 8 a.m. This is time of that is 12 hours thereafter. And abduction is defined in 362, my lord, where it says whoever by force compels or by deceitful means induces any person. Is convict.
362 is not itself as an offense.
No, man, 362 defines
362 with certain more intention in order to commit murder, in order to demand ransom.
Exactly, my lord. So
When
360.
simpliciter is not an offense. There is
No,
no punishment.
I'm not saying that, my lord. See, he has been convicted under 364. 364 says whoever kidnaps or abducts, kidnapping will come, my lord, so far as minor is concerned, or somebody with a guardian, my lord. So here it will be case of abduction. Abduction is defined in 362. That is what I'm submitting. Whoever kidnaps or abducts any person in order that such person may be murdered. So motive has to be there. Mens rea has to be there from the very beginning. And paragraph 43 says of the judgment that so far as the motive is concerned, though the prosecution has not specifically brought out anything on record, prosecution has conclusively established that the accused persons in a pre-planned manner committed murder. My respectful submission that is self-contradictory, my lord. And one more aspect, my lord, so far as the TIP is concerned, my lord, the witness who had exhibited 10, my lord, the magistrate, my lord, a suggestion is given, my lord, that the witnesses had got the opportunity to come in contact with the accused persons, which of course he has denied, my lord.
Negative suggestion as a note.
No, I had come across a judgment where the Supreme Court has said that whatever is the version of that was of course a civil case, the defendant's version has to be put to the witness. That is the importance of my version I have to put, because if she says something positive, my lord, I may not have anything to controvert. So the only way out is a suggestion, my lord.
Then suggestion, if something more is thereafter, then it gets some weight.
But here,
But-
from here it appears that the suggestion
Suggestion
was given.
simpliciter remains in the realm of suggestion only.
But here I think the suggestion was given, now the
to
witnesses
put
have
up a
come in.
story which should be believable, so that you can put up in your cross-examination thereafter 313 if required defense evidence. And on the basis of other materials.
In any
Yes.
case, my lord, it will not be substantive evidence, my lord, that my submission is there. Obliged.
My lord, firstly, my humble submission, lordship. I want to point out one thing, PW1 and sketch map, lordship. In the, may I read, lordship, few lines. In page number 11, lordship. I have a Maruti van. The incident took place on 8/1/2014. My driver went out along with my Maruti van. Later, he informed me over phone that he had gone to Thukwakhana to drop 2 persons, lordship, known to him. But since he did not return,
Mr.
I-
Das,
lordship, I only want to think,
one thing I
Lord.
just want to put out, that for a timing, before you make submission, let us, for a timing, not take bottom-up approach.
lordship,
Let us take top-down approach,
lordship,
not bottom-up,
lordship,
top-down.
lordship.
What do you say about 9 and 10?
I will, lordship. I will, lordship,
Otherwise, bottom-up, it will be pyramid.
lordship,
Let us come from top to down.
lordship.
PW 9 and 10.
I will submit on that, lordship.
PW 10 says he saw the 2 persons in the taxi stand for the first time,
Lordship,
right?
lordship,
PW 9, he said, I did not know their name at the time of incident.
lordship.
But while testifying before the court, how did he know their names?
9, lordship. Because if I look into the lordship, the CD lordship, it is there. How he can know, lordship. In the CD lordship, he has
Yes.
stated that he has identified, he can identify. He don't know the persons. He can identify. So when he first.
That is what I have put. He touched.
Lordship,
In the TIP, he touched.
lordship,
Is it not?
lordship, he describe also, lordship, in CD lordship.
Huh?
Description of the
So
persons. are
how
also
did he name? Name them.
Later, he may know, lordship, the name of the accused persons. That is because he don't state that on the dock, lordship, he
He was
recognized.
a cultivator otherwise.
Lordship, if I, in PW1, if I allow to read, lordship, the lasting theory will come here only, lordship.
How?
That is why I am coming on to
Last in
that.
theory.
Lordship. That is why I want to focus on that point, lordship.
Yes, please.
But since then he did not return, I rang him up. The driver, Jogeshwar Sutia, told me that he had crossed Khilamara Sampara bridge. That means after that, no communication is there, lordship. But the driver did not return. After that, no communication is there, lordship. So last communication is Khilamara Sampara bridge. And to that point, there are two persons are there. He has stated. If I look into the sketch map, Lordship, it is in 98. Lordship. That bridge is RCC bridge, Lordship, and few meters before that forwarding, Lordship, the dead body was found. And if we look
Where?
at the upside, Lordship, SH42 way from Gogamukh to Dhukuakhana via Hilamara. So it will go to Dhukuakhana, Lordship. So up to that point, these two persons are with them. This bridge, Lordship. What is talking about PW1, Lordship? After that, no communication is there. Until that point, two persons are there. After that, his dead body is found. And if I look into the PW7, Lordship, PW7, the brother of the deceased, he stated that, Lordship, may I allow to be read? That is why I'm saying that this is a last seen theory, Lordship. Because after that, no communication is there. It is also wrong submission, Lordship, that he is returning from there. Because if you look at the sketch map, Lordship, it clearly shows it goes to Dhukuakhana, Lordship. If you look into the PW7, Lordship, the boys who were present at the taxi stand told us that accused Mintu Setia, along with the brother boy, hired the said vehicle to go to Dhukuakhana, 23, Lordship. We informed the police. Mittu Setia is also named, Lordship. And one of the witness, maybe Lordship PW11.
Maybe and maybe,
They,
maybe.
I am
might
not
be,
on that,
shall
but
be.
it is their statement only. Mittu Setia is there. And moreover, it is last, when he is called to this PW1, up to that point, two persons are there, Lordship. Only two persons. And after that, he died. In the sketch map, it is clearly shown, Lordship. If we look into the sketch map, Lordship.
But they have hired a vehicle at about 8 AM.
Lordship.
Last one was at 8 PM. The distance between Hilamura and Upper Bridge is how much? Please, as shown by the council for the land is 18 kilometers. So whether in 12 hours they could cross only 18 kilometers.
Mr. Das, whether the concept of last seen theory can be extended to last heard theory? Concept of last seen together theory can be extended to last heard theory.
No, Lordship.
PW1, which you have said that last seen theory, it appears to be last heard theory.
But up to that point, two persons are there only. The
Right,
driver
it
is
is
there.
last seen or last heard? Whether this concept, last seen, can be extended to last heard.
It is fact, Lordship. We stating about the facts, Lordship.
So you have said last seen,
Sorry, maybe Lordship, but it is
last heard.
Lordship. And moreover, Lordship, PW9,
PW7, that one is told us.
Lordship.
That is what? That falls in which category of evidence? Told us, PW7. What category of evidence is this? But it comes under section 61 Evidence Act.
No, Lordship.
Huh? Should we treat this as evidence?
PW9 Lordship stated that he was present at that time.
Ah, yes, PW9.
Has stated himself, Lordship, he was present at that point of time.
This PW7 went to the taxi stand later on.
Lordship.
Single benches also. But I don't think last third theory is applicable here. Well, you have heard Mr. Whitehead. Whitehead. Learned counsel for the appellant in 5. And Mr. N. Reka learned amicus curiae for the appellant in 6. Full stop. As the submission of Mr. K.K. Das, learned additional public prosecutor for the respondent state is not complete, release the case, appeals, release the cases again on Tuesday.
18-6. My lord, I have a prayer, my lord, in item number 8, my lord. It was actually shown as part heard, my lord. So if your lordship may-
Not shown as part had,
because there was an order.
we're taking up. It is
Like
not
your
that we are
lordship
not taking.
may take up on any other date or release, my lord. Then
There's an order dated 24/4/2024. Listed on 8/5 for further hearing. Non-recurrent and lease before appropriate bench given. 8/5.
Not kept as part had.
my lord, subsequently on 8/5, it was taken before
Due to
another bench.
paucity of time. You have made it part hard before another coordinate bench. Saying that it is part hard.
Actually, it was indigenous further hearing. That's why, my lord, earlier bench thought, my lord, that it is.
It will join other something.
There is no order as such.
Yes.
8/5 order does it, no? 24/4.
24/4/24, there is a order, my lord. Because on
Part,
that
I
day-
have seen it.
My lord.
And then you have made submission before another coordinate bench, it is kept part hard.
Not there.
Due to paucity of time, the appeal could not be taken up today. Mr. B. Burwal and counsel for the appellant. And MS B. Bhuya learned additional public prosecutor for this. Yes, sir. This is not good. This practice. Read the case in the next week. Matter is not to be treated as part of.
My lord, item number 9, can it be on next week, my lord?
Not possible, we have already fixed many matters. 9,
9 met appeal, my lord, because there is some urgency, my lord.
we
Says-
have fixed
says
many
some loan
matters,
lordship
Mr.
bank is also
Talukdar,
pressing,
not
my lord.
possible.
Says,
Not
some loan
possible,
amount is
Mr.
pending and bank is also pressing, my lord. She
Ah.
has permanent matter is regarding permanent alimony, my lord. She has a
Right,
loan
not
and bank.
possible, Mr. Talukdar. We have fixed many matters for disposal.
May I please, Your Lordship? Your Lordship, I need some accommodation in item number 7. And the matter may be taken up after the vacation.
Okay, on the prayer of Mr. B. Prasad,
Yes,
on
ma'am.
on the prayer of Mr. B. Prasad, oh, sorry, Mr.
PJ Bora.
P. J. Bora.
J Bora.
J. Bora.
Huh.
J. Bora, Learned Counsel, appearing on behalf of Mr. B. Prasad, Learned amicus curiae for appeal, has sought for an adjournment on the ground that there is medical difficulty on the part of Mr. Prasad. His wife is hospitalized. In view of the ground cited, Miss B. Bhuya, Learned Senior Counsel and Additional Public Prosecutor for a respondent state, has submitted that there is no objection from the end of the state. First, the case stands accordingly adjourned for 2 weeks.
So the subordinate courts of the DC of Arunachal Pradesh, Your Lordship. There are employed as the drivers in the subordinate courts there.
How many? 12, 13?
13 in numbers. Your-
Hmm.
They've come here being aggrieved by the non-availability of promotional avenues from the post of driver, Your Lordship. There
What
is
will
no,
be the promotional avenue?
yeah, there is no
Otherwise-
promotional avenue actually, Your Lordship. If I may, Your Lordship, the service of drivers are this by the Arunachal Pradesh
Is there
State
any
District.
service rules?
Yes, Your Lordship. The service of Arunachal Pradesh State District Court Service Rules 2013, Your Lordship.
Where are the post of driver?
Annexure 3
And
is start from page number 17, Your Lordship.
page number?
Page number 17. The rules.
Yes.
If I may take Your Lordship to first rule 3, sub-rule 2, Your Lordship. At page number 18, Your Lordship. The service shall consist of the category of posts or or cadres specified in column 2 of Schedule A. The character and number of posts in each of those cadres and their scale of pay shall be as specified in the corresponding entries in column 3 to 6 thereof. If I may now take Your Lordship to Schedule A, Your Lordship.
Page?
Schedule A is at page number 22, Your Lordship.
Who is the standing out?
Lordship, they were supposed to appear by BC, Your Lordship. And they were there, I think. But now,
Court by Arunachal. আৰু আমাৰ এইটো চাওঁ কজিছখন চাওঁ। I think standing counsel from Guwahati High Court should appear. I think in person or virtually.
as
Is
far as
there
I'm
a
concerned,
standing counsel in Itanagar bench?
I believe it's Mr. Partin here, Lordship.
Party. His name is shown.
Yes, his name is shown there.
And what about government of Arunachal Pradesh?
Government of Arunachal Pradesh, I believe their party is there. Your Lordship.
They have missed the link or what?
It was connected. Okay. Connection to was,
Let us page 22.
yeah, just at the bottom, you also schedule A. Now, page 23, Your Lordship.
Hmm.
At the topmost, serial number 10,
Hmm.
drivers.
Hmm.
13 number of posts, Your Lordship, all total. And the pay scale in the payment 2, 5,200 to 20,200 with grade pay of
What is the
1900.
qualification?
Qualification will be coming at schedule C, Your Lordship. At page 24 or 25, Your Lordship. At serial number 10, driver. The recruitment process is by direct recruitment, failing which by transfer, deputation, or absorption. And the required qualification is must have ITI certificate in driving and shall have such experience and knowledge of major, minor repairing, propelling of light, heavy vehicles with valid driving licenses or equivalent.
In the services, I don't think there is any suitable post for promotion
Yes, Your Lordship.
with this kind of qualification. Then promotion post is to be created.
It was created, Your Lordship.
Promotional avenues is to be created.
Yes, Your Lordship.
There is a situation
There is.
because this kind of qualification is not required in any other post.
Yes, Your Lordship.
ITI certificate in driving. That is not the requirement for LDA,
No, Your Lordship.
upper division clerk,
Yes.
fast car. So lack of promotion level.
Lack of professional avenues. Your Lordship. They have been stagnant in
Simplicity.
2013.
What is the position in principal seat
Uh,
or say in Assam?
I have not been able to get a hold of the service rule here, but I have been told, Your
Real
Lordship,
service was 1987,
there are some. I have
two
not-
states.
As far as I'm concerned, there are grades within the drivers, providing for promotion within the driver category. From grade 3, grade 2, grade 1, and some, I believe. There are similar proposal avenues in other states also, Your Lordship. Even in Mizoram, if I may take Your Lordship to Annexure 5.
Page.
Annexure 5 is the Mizoram District Court Service Rules, Your Lordship. At page 34, Your Lordship. Lordship will find at the bottom, driver grade 3. Then there is driver grade 2 by promotion. Then driver grade 1 by promotion. Similarly, there are other states also, Your Lordship. I have annexed those service rules also.
Page.
Of Tripura at page number 40, Your Lordship. When the same procedure is followed as in Mizoram, driver 3 junior in group C, driver 2 senior in group C, then driver 1 in group C. There's a promotional avenue from 3 to 1. Then basically the issue is there, Your Lordship,
Art
there is no
Mr.
proof.
A.R. Google. Land Council for the petitioners. Full stop. Link to आना ही नहीं. Yes.
So I'm representing the respondent number 1, Guwahati High Court. So at this stage, notice may be issued and directed to the petitioner to serve the extra copies.
And Mr. M. Partin, learned senior counsel and standing counsel, Guwahati High Court, Itanagar bench,
Itanagar bench.
for the respondent number 1. Full stop.
Assisted by
Assisted by
young D,
T.Y. Bhutia.
T.Y. Bhutia.
TUI Bhutia. Learned Council. For the respondent number 1. Full stop. Though the names of learned government advocate Arunachal Pradesh for the respondent number 2 and 3 are reflected in the cause list. None has appeared for the said respondents to the on-call. Full stop. The petitioners, 13 in number, were appointed as staff drivers in various subordinate court establishments in the state of Arunachal Pradesh under the jurisdiction of the Guwahati High Court. And they are presently serving as such. Full stop. It is projected that the recruitment and conditions of service of drivers are regulated and governed by the Arunachal Pradesh State District Court Service Rules, 2013, framed under in exercise of the powers conferred by the proviso to Article 309 of the Constitution of India. Full stop. It is a case of the petitioners that Rules 2013 for short. There is no promotional avenues for drivers appointed under the Rules 2013. Full stop. Drawing reference to the Mizoram District Court Service Rules, 2011, and Tripura and the Tripura District Courts Ministerial Establishment within bracket Recruitment and Conditions of Service bracket close Rules 2014. The petitioners have submitted that in those rules, promotional avenues have been provided for employees who were recruited initially in the post of driver Roman 3 to higher post of driver Roman 2 and driver Roman 3 post of. Do you have the Raghunath case? No.
No.
Huh? Tripura, Supreme Court?
I'll get it.
Go through it. As the petitioners have remained stagnant since their initial appointment, the petitioners, the instant repetition is preferred, seeking promotional avenues, seeking inter alia direction to the respondent authorities to formulate a promotional scheme for drivers appointed under the rules from 2013. Post of the basis of post of as it is the case of the petitioner that there should be the rules should provide for at least 2 promotions in the service careers. So issue notice returnable on after 4 weeks. As MS Bhutia, Learned Counsel, assisting Mr. Patil, Standing Counsel GSC, has appeared and accepted notice on behalf of the respondent number 2. Issuance of formal notice terms to the said respondent number 1 is dispensed with. However, Mr. Gogoi, Learned Counsel for the petitioner, shall furnish an extra copy of the petition to MS Bhutia within 7 days, within a week from today. First of Mr. Gogoi and Counsel for the petitioner shall also supply requisite number of extra copies of the writ petition along with annexer to Mr. NNB Chaudhary. I think he is Additional Advocate General.
He's Additional Advocate General.
To Mr. NNB Chaudhary, Learned Additional Advocate General, Arunachal Pradesh, within 3 working days from today. The respondents shall make endeavor to file their responses on or before the returnable date.
17/7.
Obligable.
For hearing item number 1 and 2.
Second. You are taking up which petition?
Lordship, that 2845. So Lordship, I have mostly completed my submission as far factual stuffs are concerned. So basically, Lordship, I submitted that this operational guidelines, the first point is that operational guidelines, which was framed basically to execute the policy of the government. So the provisions of that cannot be in contradiction to the policy. So if, by this guideline, there was there was a definition given in the policy. So in that definition, certain other issues have been included in the policy, which cannot be done by operational guidelines. So it can be supplemented, but it cannot be supplanted. So it cannot override the effect of the policy. That is the first point, Lordship. Second point was that, Lordship, as far as government speaking in 2 voices, what I will submit is that, Lordship, before issuance of this eligibility certificate, there was a committee, AIDC committee is there. AIDC committee is the supreme committee which was supposed to give the eligibility certificate. So tax department, finance department was consulted. Then there was some confusion happened, internal communications happened, and IIDC has ultimately took a decision to reject it.
So government is not speaking in two voices. Because it is
Ultimately, where a rejection is,
second case, Lordship, second
second
case,
is,
yes,
rejection is.
page 191, Lordship. So AIDC has ultimately took a decision. AIDC is the committee. Government is not the authority which is going to give eligibility certificate. Eligibility certificate will be given by the committee only. So committee has taken a decision. Ultimately, AIDC has taken a decision. So these are the 2 points, Lordship, I have.
191.
191. And it has been pointed out, Lordship, that page 118 and later, Lordship, that extract was given from the comment from the finance department. So that was forwarded to the AIDC. So that means the government is in consent with that. Yes. So, Lordship, as far as factual part and my legal submission was that, and in that regard, Lordship, I will place couple of cases, and my learned senior has placed certain cases, so I'll try to distinguish those.
Can you give a short synopsis of your submission, point wise only, or confining to one or
That will prepare us. That will
1 or 2 page?
We'll give it. We'll give it.
Yes, decisions.
The decision was the
1, 2.
first decision that I would like to rely upon, Lordship. This is, Lordship.
Also mention in that synopsis that the decisions,
I'll do that, Lordship.
so that I'll not write.
Yes, Lord. I'll make it. So this is, Lordship, 2007-8 SSC 189.
Copy.
Oh, wait. Sorry,
Yes.
Lordship, para 13, 14, 15, 16.
Para
13 to 13, 15, 16, 19 and 20 notes.
15, 16, 19.
And 20 notes.
Yes, that is inclusive.
2007 8 SSC
2007. 8 SSC
189.
189.
State of Odisha versus Tata Sponge Iron Limited.
Yes.
There are 30 may I read, Lordship.
Yes.
The High Court passed the impugned judgment inter alia on the premise that operational guidelines being in the nature of a subordinate sub-delegated legislation, the same was required to be in consonance with the IPR. There is a policy, Lordship, and by reason thereof, no other or further condition could have been stipulated so as to prevail over the policy decision itself holding. If we accept the contention advanced by the learned counsel for the revenue that the operational guidelines provide a limitation or time period for sales tax incentives, it would tantamount to accepting a principle that by sub-delegated legislation, a delegatee may also effectively amend or supplant the supplant legislation, which it is clearly incompetent to do. On a reading of the said operational guidelines and the terms thereof would clearly indicate that the stipulations regarding the time period find mentioned in clause 5 of the operational guidelines. It would be clear that the said stipulation would relate only to those industries covered under para 7.3 and 7.4 of IPR 1992 and would be limited to apply to those industries only to which time periods have been stipulated in the IPR itself and not to the industries activities covered under paras 7.2 and 7.5. Since the petitioner's industry is covered in the EMD category under para 7.5 of IPR 1992, read with entry 44 SRO number so and so, clause 5 of the operational guidelines cannot be said to apply to it. We are of the view that the clause 5 of the operational guidelines and the stipulation in the eligibility form
to the extent that it provides for a period of time is not in consonance with the IPR 1992, is clearly without jurisdiction, without sanction of law, and is also ultra vires IPR 1992. The operational guidelines and or instructions were made for administration of incentive contained in the policy and not for the purpose of imposing any new stipulation and or conditions alien to and or not in consonance with the passing of the 1992 policy. Such a stipulation cannot in law be read into and allowed to operate, since it would frustrate the very object sought to be achieved by the 1992 policy declaration. It is furthermore held, drawing an analogy from the aforesaid principles of law, we are of the view that the incentive under para 7.5 read with entry 44 as notified in SRO number so and so, exemption of tax did not provide any period of limitation. Neither IPR 1992 nor the Finance Department notification in SRO number 1019 of 1992 provided any stipulation as to how long the exemption from sales tax would remain in force, and therefore the position that emerges therefrom is that such exemption granted under the notification was to remain operative till the industry utilizes and exhausts the incentive granted to it. The petitioner is entitled to such benefit till such time such exemption is allowed to remain in force without being withdrawn by subsequent notification. It is important to point out here that no such notification withdrawing such exemption has been brought to our notice in course of hearing. Then, para 14, Lordship, indisputably, pursuant to or furtherance of the aforementioned IPR 1992, the state government amended the provisions of the Odisha Sales Tax Act, Section 6 of the said Act reads as under. Tax-free goods, the state government may by notification, subject to such conditions and exceptions, if any, exempt from tax the sale or purchase of any goods or class of goods, and likewise withdraw any such exemption. Indisputably, again, pursuant to or in furtherance of the aforementioned provision, Finance Department of the State of Odisha had issued notification bearing number so and so, dated 23/9/1992, and inserted entry 44 in terms whereof the respondent became entitled to exemption. Entry 44 of the said notification reads as under. 44. Sale of finished products of an existing industrial unit located in Odisha, that is industrial unit which has gone into production before 1st August 1992 and which has undertaken expansion or modernization and diversification of the said unit after the first day of August 1992 on the basis of separate project report duly appraised by the financial institution, and such a certificate to the effect that is regarding expansion, modernization, diversification of the unit is produced from the general manager concerned, project manager, district industry center in case of small scale units, and a certificate in form so and so is produced from the director of industries Odisha in case of medium and large and pioneer units. The exemption of sales tax shall be limited to 60% of the additional capital investment in plant and machinery only in Zone C, and 75% of the additional capital investment in plant and machinery only in Zone B, and 100% of additional capital investment in the plant and machinery only in Zone A. Explanation: additional capital investment in plant and machinery means additional investment of 50% or more of the undepreciated book value of fixed capital investment of an existing unit in acquisition of plant and machinery for expanding, modernization and diversifying the production of the said unit, provided that benefit of the exemption is admissible only on the incremental sales arising out of such expansion, modernization and diversification, provided further that no exemption as indicated above shall be allowed to the following categories of industries, namely so and so. Further, the eligibility certificate granted for sales tax concession on the sale of finished products categorically states that exemption may be available as per Finance Department notification so and so as amended from time to time up to ceiling amount of 100% of additional capital investment, 75% and 60%. It is not in dispute in the said entry during which same would remain operative. No period for less the period of 5 or 7 years had been mentioned. The only limitation prescribed thereby was that only 75% of additional capital investment in Zone B would be allowed, where the unit of the respondent situate. Then para 19, Lordship. A bare perusal of the said notification would clearly show that whenever a period up to which the exemption could be obtained was required to be stated had specifically been done therein. For example, serial number so and so, we may further notice that against entry 44, however, what is mentioned is the extent to which such exemption would be granted. No period during which such exemption is to be obtained was stated. In other words, no period of limitation was fixed thereby. In view of the clear legal provision, as also the aforementioned notification so and so, there cannot be any doubt whatsoever that the exemption in respect of the determinant of sales tax having been provided for under Odisha Sales Tax Act, as also the notification issued there under the High Court is, in our opinion, is correct in taking its view. So here, Lordship, there was no limitation of time was given. Only the percentage was given, the limit was only the percentage. But by these guidelines, by this subsequent notification, a limit was tried to be brought in for 5 years and 7 years. So this Supreme Court, Honorable Supreme Court says that it cannot be done. Which was not there in the policy, you cannot bring in a new by way of an operational guidelines. So the other case, Lordship, I would like to rely on. This is, Lordship, 2022-23 SSC online, Supreme Court 1584. You know, this is regarding, Lordship, like supplement and supplant. Para 48 and 49 units. Para 48, Lordship will find it internal page 14 units. May I read out on this?
Yes.
We further find that the 2012 service rules as framed by the state of Uttarakhand were framed on the basis of notifications issued by NCTE on 23rd August 2010 and 29 July 2011. These 2012 service rules were amended from time to time as existing on the date of advertisement. They specifically provide for a 2 years DED course known as BTC, training in the state of Uttarakhand as a minimum qualification. It also provided that a person to be eligible to apply for the said post must have completed 2 years DED course from NIOS and qualified teacher eligibility test that or has completed 2 years DED course from any other institute recognized by NCTE and qualified TET. The advertisements issued by various district education officers also provided the same qualifications. It can thus be seen that acquiring of 2 years diploma in elementary education was a minimum qualification as prescribed under the statutory rules. It will be apposite to refer to the following observations of this court in the case of Employees State Insurance Corporation Supra, wherein this court has referred to its earlier judgments, including that of a constitution bench. The constitution bench in Santaram Sharma versus State of Rajasthan, AIR 1966 Supreme Court 1910, considered the applicability of letters issued by the government of India detailing the administrative practice of promotions against the Indian Police Service, Regulation of Seniority Rules 1954. The Constitution bench held that we proceed to consider the next contention of Mr. N.C. Chatterjee that in the absence of any statutory rules governing promotions to selection grade posts, the government cannot issue administrative instructions, and such administrative instructions cannot impose any restrictions not found in the rules already framed. We are unable to accept this argument as correct. It is true that there is no specific provision in the rules laying down the principle of promotion of junior or senior grade officers to selection grade posts. But that does not mean that till statutory rules are framed in this behalf, government cannot issue administrative instructions regarding the principle to be followed in promotions of the officers concerned to the selection grade posts. It is true that government cannot amend or supersede statutory rules by administrative instructions. But if the rules are silent on any particular point, government can fill up the gaps and supplement the rules and issue instructions not inconsistent with the rules already framed. 16. In Union of India versus Ashok Kumar Agarwal, 2013-16 SSC 147, a two-judge bench of this court, speaking in the context of service regulations governing a departmental inquiry, reiterated that an office order or office memorandum cannot contravene statutory rules. B.S. Chauhan judge noted the position in law in following terms. The law laid down above has consistently been followed, and it is settled proposition of law that an authority cannot issue orders, office memorandum, executive instructions in contravention of the statutory rules. However, instructions can be issued only to supplement the statutory rules, but not to supplant it. Such instructions should be subservient to the statutory provisions. White Union of India versus Maji Jagamaya, reported in 1977, 1 SCC 606. Then lordship, some case laws have been referred to. Then 17, in PD Agrawal versus State of UP, a two-judge bench of this court declined to grant primacy to an office memorandum issued by the government of Uttar Pradesh, which purportedly amended the method of recruitment of assistant civil engineers in UP Public Service Commission without amending the relevant regulations. The office memorandum dated 7/12/2061, 1961, which purports to amend the United Provinces Services of Engineers, Buildings and Roads Branch Class 2 Rules 1936, in our opinion, cannot override, amend, or supersede the statutory rules. This memorandum is nothing but an administrative order or instruction, and as such, it cannot amend or supersede the statutory rules by adding something therein, as has been observed by this court in Sant Ram Sharma versus State of Rajasthan. Moreover, the benefits that have been confined on the temporary assistant engineers who have become members of the service after being selected by the Public Service Commission in accordance with the service rules are entitled to have their seniority reckoned in accordance with the provisions of Rule 23 as it was then from the date of their becoming member of the service, and this cannot be taken away by giving retrospective effect to the rules of 1969 and 1971 as it is arbitrary, irrational, and not reasonable. Then 49, Your Lordship. It can thus be seen that it is a trite law that government cannot amend or supersede statutory rules by administrative instructions. But if the rules are silent on any particular point, it can fill the gaps and supplement the rules and issue instructions not inconsistent with the rules already framed. It is settled proposition of law that an authority cannot issue orders, office memorandum, executive instructions in contravention of the statutory rules. However, instruction can be issued only to supplement the statutory rules, but not to supplant it. So, Lordship, in this case also, substantial expansion was defined in the policy, and as per the policy, the scheme by the tax remission scheme was framed. In both this policy as well as the tax remission scheme, that one definition has been given. But by this operational guideline, there are additional 2-3 definitions were included in the operational guidelines, which gives additional benefits to certain people, which were otherwise not eligible under the policy. So that cannot be done.
You want to say that the operational guidelines have supplanted the policy.
Correct. By adding these two new sets of like units which go for modernization and process diversification. So that cannot be done, Lord sir. That's my humble submission on this,
What is the status of the policy?
Lord sir.
What is the status of the
The
policy?
policy is expired long time.
No. What is the status of the policy?
Policy is a
It
lot
falls in
of,
the category of what?
it's kind of a,
Whether it can be given the status of a statute or statutory rules.
it's lots of it is policy is framed under a cabinet decision, Lord sir.
Cabinet decision. What is the status?
So it's almost like
Oh,
it's.
There are long lines of decisions perhaps.
Correct.
So this policy is not in stricto sensu.
It's not in the stricto sensu, that is correct, but
So
it's,
to supplant or to bring in the concept of supplanting.
not so.
So whether this is what is the category? Santaram Sharma, everybody knows.
Correct, Lord sir.
Constitution,
Yes, Lord sir.
statutory rules.
Yes.
So office memorandum, instruction, it may be issued to fill up the gaps, but not to override it or supplant it. Now, same analogy is applicable in case of this industrial policy.
So that's what, Lord sir, my submission will be. It's because it has been taken by a cabinet decision. Cabinet approval is there. Cabinet is the highest authority. It was only thing is that, like, as far as statute is concerned, that has to go through the passing a bill and all, but that hasn't been done. But it's a policy which is there for a long-term policy. It's for a 5 years policy. So it's the same analogy will be applicable to this, Lord sir.
Write down that point.
Lord sir, I'll write that. Then, Lord sir, one case law, Lord sir, that this honorable court judgment, my learned senior has placed, Lord sir, that Ladi Steel Industries, that has been placed, Lord sir. Okay, Lord sir.
Yes.
Yes, Lordship, got it. Lordship, I would like to refer to para 23, 24, 25, and 26. Lordship, in this case, what has happened? I just bring a short summary, Lordship. In this case, what has happened? Lordship?
There in paragraph 18, you made a submission.
Yeah, paragraph 18, I made a submission, Lordship.
It is a policy which is a substantive law, and the guidelines which has been notified in
Correct.
terms of the policy cannot supersede the substantive law.
Correct.
He further adds that even if the guidelines may take the color of a delegated legislation, the said guidelines cannot be taken into consideration for matters which are directly in conflict with the policy. The same submission.
The same submission.
But
here,
the
Lordship,
policy does not provide for such incentive by the guidelines. Providing for such incentive is not permissible. What is the answer of the court?
no, Lordship, yeah, here, Lordship, a factual thing was little bit different.
No.
Why
The-
this submission was made?
no.
That there was
Point is substantive law and operational guidelines cannot supersede.
correct.
What is the
Lordship.
finding on the?
The finding,
submission?
Lordship, what this honorable court stated. That, Lordship, here, Lordship, the definite finding was not given, Lordship.
Tata Sponge you have referred to,
Refer to, Lordship. But
that is dealt with.
that is dealt with in a different manner, Lordship. That, Lordship, I would like to place before your Lord, submit before your Lordship.
That I'll be coordinate bench.
Coordinate bench, Lordship, but Lordship can always have a different view.
And that view is to be referred to division bench.
No, Lordship, no, here,
I
Lordship, no,
agree,
here-
then I
no,
can
Lord-
go by.
correct, Lordship. Lordship, here the factual stuff is little bit different. Lordship.
No, but
Ah.
this is not in reference to paragraph, I think, 29, 30 and 31. Let us read first to understand the exact position.
The Lordship, that's why, Lordship, I would like to, Lordship, the factual stuff was like something like this, Lordship. Here, Lordship, this unit was already given a eligibility certificate. Then, Lordship, what has happened? They sought for some benefits under the MCME Act, saying that it's a micro, small and medium industry, which was not given by the approved by the.
But this is without any rider, paragraph 31.
So, Lordship, what it has, the court has
Paragraph
said.
31.
Yes, in the instant case, the court has noticed that it is the case of none of the parties their operational guideline was a subject matter of challenge.
Then next.
Here, Lordship, we have that there is an objection about certain provisions of the operational guidelines. The court is of the view that guidelines which were framed under Chapter 12 was only to supplement the policy and make it workable. And till such guidelines were existing, it was obligation of the authorities to follow the same. So here, Lordship, what has happened, the factual stuff, Lordship, I'll have to explain it a little bit. Lordship, may kindly come to paragraph 23, Lordship. What has happened in this case? May I read it, Lordship? The issue involved in this case is necessary to be examined from the context of the first approach of the petitioners to the court by way of filing WPC 5421 of 2013. The grievance expressed in the earlier writ petition, which would itself be discernible from a reading from the aforesaid order dated 19/2/2014, is that while making the assessment, the petitioner number 1, instead of being treated as small enterprise, was treated as medium enterprise. This court has also recorded that the remand was made on consent of the parties to do a rectification exercise within a particular period. So there was a remand, Lordship. There was an order of this Honorable High Court. The order of remand being confined to a particular aspect, that is, as to whether petitioner unit was a small scale unit or medium scale unit, it is actually questionable as to whether any other aspect would have gone into on such remand. More so, when the assessment done while issuing the first eligibility certificate dated 12/7/2010 was otherwise not subject matter of any challenge. So, Lordship, it was remanded for a particular purpose. Then, Lordship, it was reopened. In this case, the first eligibility certificate dated 12/5/2010 clearly reveals that towards the component of electrical installation other than drawal of power line as stated in serial number 4G, an amount of rupees 63,52,117 was assessed as additional investment made for substantial expansion. There is no issue raised by the respondents on the factual aspect of the matter regarding such additional investment. The present controversy has arisen only while issuing the subsequent assessment order pursuant to the remand order of this court, where the component of electrical installation other than drawal of power line under serial number 4G has been held to be nil. So they have taken away this, Lordship. This issue was not before the Honorable Court. Remand was for a different purpose. The second eligibility certificate, now Lordship, the second eligibility certificate at para 25, the second eligibility certificate dated 23/6/2014 does not state any reasons as to why petitioner unit was held not to be entitled to any amount under the aforesaid component. The grounds for such action can be traced back to state level committee meeting held on 31/5/2010, wherein it has been held that operational guidelines cannot supersede a policy. So, Lordship, what has happened? In 2010 only this issue was raised while issuing this eligibility certificate. But this issue was subsided and they have issued an eligibility certificate already. Then while issuing the second eligibility certificate, they have took up this issue and they denied it. But the case was basically remanded for a different purpose, Lordship. Para 26, Lordship. This court finds force in the submission made by the learned senior counsel for the petitioner that the first eligibility certificate itself, which is dated to 12/7/2010, was after the minutes of the meeting, which was on 31/5/2010. So already it was given. Whether a state level committee would have jurisdiction or competence to question the operational guidelines framed under the policy itself is a debatable issue. In any case, the operative part of the observation is a recommendation to rectify the operational guidelines by issuance of a necessary corrigendum. There is no manner of doubt on the part of the court that state level committee will not have the competence to declare operational guidelines as invalid. It would be a different matter if such guidelines were ratified by the competent authority, which is in this case was not done at the relevant point of time. So, Lordship, it was in that context. The case was referred for a certain issue. Then the department took up a different issue, and in that context, that operational guideline has come into play. So para 29, Lordship, Tata Sponge was referred by this honorable court. So far as the decision of Tata Sponge referred by Sri Kalita Learned Standing Council is concerned, the facts of the said case are wholly distinguishable from the facts of the present case. So that case and this case is obviously different, Lordship. In the said case, the grievance was raised by the SSC, which had alleged that the issuance of a subsequent guidelines, the substantive part of the policy by which the unit was claiming incentive was sought to be taken away. So Ladi Steel's case and that case, Tata Sponge case, Lordship, is factually maybe a little bit different. But in this case, Lordship, in the case on hand, the Tata Sponge case, Lordship, it's fully applicable. So there, Lordship, already one eligibility certificate was already issued. Here that stage hasn't come as yet.
So what is the sum and substance of Tata Sponge?
The Tata Sponge, Lordship,
High Court looked into the policy, 1992 policy.
Yes, Lordship.
And the operational guidelines.
Lordship.
And found that in respect of some of the
time limit has been.
Industries, time limit was provided.
Yes.
And in some of them, in respect of some of them, it was silent.
So 5 years and 7 years have been provided for. There are 3 categories of industries. So 3 categories, they have included the time limit.
So reading those clauses, 7.3, 7.2, 7.4, and 7.5.
Yes, Lord.
High Court called out that in respect of entry number 44, there is no time limit. We are of the view that clause 5 of the operation guidelines and the stipulation in an eligibility form, to the extent that it provides for a period of time, is not in consonance with 1992, is clearly without jurisdiction, without sanction of law, is also ultra virus IPR 1992.
Yes, Lord.
So operational guidelines there had gone beyond the
beyond the IPR.
policy. Now, where is this? It has gone beyond.
Where in our case,
Huh?
case on hand,
This three meanings, three meanings. Three
Yes.
meanings of substantial.
correct, Lordship, that they have included this, the additional things. So like the additional benefits have to be given by the state.
After the operation guidelines, is there any clarificatory notification at any point there
No,
subsequent?
there was nothing.
No. That, okay, there's some confusion has been, because this is filed in 2014.
Lordship,
We have traveled 10 years.
correct, Lordship.
So any clarificatory,
Because the matter was subsidies, Lordship, no clarification has been issued. The policy was, Lordship, lapsed long time back. Policy was there till 13 only. So under the policy, Lordship, nothing can be done. Because 2014, then in 2014, the different set of policy came.
okay,
So these two cases, Lordship, I have relied on, and then I tried to distinguish this still, Lordship. Then now, Lordship, there is a compilation given by my learned senior. So he has relied on a couple of cases, Lordship. I will try to point out a couple of paragraphs from those cases. Lordship, as far as Lordship, like government speaking in two terms, my learned senior has relied on this case of Vadilal Chemicals, Lordship. It is there in the compilation. It starts from page 1 only, Lordship. So there, Lordship, I would like to take your Lordship to paragraph 22 and 23.
paragraph 20,
So government speaking in two voices,
paragraph
22 and 23, Lordship. Page 8, Lordship. So may I read out, Lordship? 22. Furthermore, another incentive scheme in question, there was only one method of verifying the eligibility for various incentives granted, including sales tax exemption. The procedure was for the matter to be scrutinized and recommended by the state level committee and district level committee, and the certification by the Department of Industries and Commerce by issuing an eligibility certificate. Here, Lordship, one thing, Lordship, that is one distinguishing factor is that certificate will be given by the this committee only. Committee will approve it. AREC committee. There was no other method prescribed under the scheme for determining an industrial unit's eligibility for the benefits granted. The Department of Industries and Commerce, having exercised its mind and having granted the final eligibility certificate, so already granted the eligibility certificate, which was valid at all material times, the Commercial Tax Department could not go beyond the same. So here, Lordship, final eligibility certificate was given, it was valid for all time. Then Tax Department has they have come in and they said, no, it's not valid. The Commercial Tax Department could not go beyond the same. More so, when the Commissioner Sales Tax had accepted the eligibility certificate issued to the appellant and had separately notified the appellant's eligibility from exemption under the 1993 GO. In these circumstances, DCCT certainly could not assume that the exemption was wrongly granted, nor did he have the jurisdiction under Section 20 of the Sales State Act to go beyond the eligibility certificate and embark upon a fresh inquiry with regard to the appellant's eligibility for grant of the benefits. The counter affidavit filed by the respondent sales tax authorities is telling. It is said that Sales Tax Department has decided to cancel the eligibility certificates for sales tax incentives. As we have said, the eligibility certificates were issued by the Department of Industries and Commerce and could not be cancelled by the sales tax authorities. So there, Lordship, the case was totally different. Final the eligibility certificate was given, it was valid for the all time. Then Commercial Tax Department has took a decision to cancel it. Then government is talking in two terms. Whereas 23-year Lordship, there is another reason why the action of DCCT cannot be upheld. The primary facts relating to the process undertaken by the appellant at its unit were known to the Department of Industries and Commerce and DCCT. The only question was, what was the proper conclusion to be drawn from this? The Department of Industries and Commerce, which was responsible for issuance of the 1993 GO accepted the appellant as an eligible in the industry for the benefits. Apart from the fact that it can be assumed that the Department of Industries was in the best position to construe its own order, we can also assume that in framing the scheme and granting eligibility to the appellant, all departments of the state government involved in the process had been duly consulted. The state, which is represented by the departments, can only speak in one voice. Having regard to the language of 1993 GO, it was the view expressed by the Department of Industries, which must be taken to be that voice. So here, Lordship, factually it is totally different. Eligibility certificate was already granted. Here, the issue of eligibility certificate was going on, and eligibility certificate was rejected by the ADC committee, Lordship. Then, Lordship, another case, Lordship, page 10, Your Lordship, State of Bihar and others, page 10 of the. This case was also relied on by my learned senior. So in fact, para 7, Your Lordship.
Yes.
So in fact, Lordship, in my view, Lordship, in my humble view, Lordship, it goes in my favor only. Para 7, coming to the second question, namely the issuance of notification by the state government in exercise of power under Section 7 of the Bihar Finance Act. It is true that issuance of such notifications entitles the industrial units to avail of the incentives and benefits declared by the state government in its own industrial incentive policy. But in exercise of such power, it would not be permissible for the state government to deny any benefit which is otherwise available to an industrial unit under incentive policy itself. The industrial incentive policy is issued by the state government after such policy is approved by the cabinet itself. The issuance of the notification under Section 9 of Bihar Finance Act is by the state government in the finance department, which notification is issued to carry out the objectives and policy decisions taken in the industrial policy in exercise of power under 7 of Bihar Finance Act. If is found to be repugnant to the industrial policy declared in a government resolution, in hand, the notification issued by the state government on 4/4/94 has been examined by the High Court and has been found rightly to be contrary to the industrial policy, more particularly the policy engrafted in clause so and so. So here also, Lordship, one operational guidelines which has been brought in later on, and the policy was already there. So here then Lordship, consequently, the High Court was fully justified in striking down the part of the notification which is repugnant to subclause B of clause 10(4)(1), and we do not find any error committed by the High Court in striking down the said notification. We are not persuaded to accept the contention of Mr. Dwivedi that it would be open for the government to issue a notification in exercise of power under Section 7 of the Bihar Finance Act, which may override the incentive policy itself. In our considered opinion, the expression such conditions and restrictions as it may impose in subsection 3 of Section 7 of Bihar Finance Act will not authorize the state government to negate the incentives and benefits which any industrial unit would be otherwise entitled to under the general policy resolution itself. In this view of the matter, we see no illegality.
It appears then sum and substance that you are disowning your own baby.
No, it's
Is it a story like this?
No, Lordship.
The policy is the parent.
Yes.
Policy is the parent.
Correct.
The guideline is the baby. You are disowning the baby.
Look, in the Lordship,
Part of the baby.
part of the baby, because there was a mistake committed, Lordship. Now that mistake has been pointed out by an approving authority. Approving authority has stated that this is a mistake committed in framing the operational guidelines because this is not as per the policy nor as per the scheme, which is made under the policy. So that mistake has been basically rectified.
So who has rectified?
Lordship.
Who has rectified?
So that was to be rectified. Then, Lordship, this
Who?
it has to be rectified by the department, Lordship, which has issued it.
Oh.
But like that,
Where is it?
that stage that hasn't come, Lordship.
Was there any stay order?
Yeah, there is just Lordship. There was stay order.
What kind of stay?
It was stay order as far as assessing of this. There was a stay order.
They have paid, probably they have paid the tax in the concessional rate. That is,
Yeah, there was a stay order.
Yes.
There was a stay order.
Even though they have not got that certificate.
If I remember correctly, Lordship, there was a stay order.
I have not seen anything.
So Lordship, in
the
this,
first-
Lordship, as far as
First
the
read petition, right?
first petition may be like
I have not
2797.
seen anything.
2797.
First read petition. Can read petition, no such order. In fact, there is no such order, it says.
I think,
Only issue notice. Only issue notice in Bunda cases. There is nothing, any interim or benefit is extended to the petitioner. There is nothing like that. Simple issue notice.
second.
Both simple issuance of notice. Notice.
Maybe Lordship, I have mistaken Lordship.
There is nothing that the petitioner has been granted any kind of interim relief.
By the time Lordship 2013, end of 2013, the policy expired Lordship. 2014, the new policy came. That is there in the read petition only Lordship. 2000 policy has been also enclosed Lordship. 2014 policy Lordship, it is there in the read petition itself. It. No, 2014 kon. It kon be capable. 14 kon ase. Page 197, that policy has been given. Hmm? 221. So this policy Lordship already expired. And the new policy of 2014 came into effect from 1/3/2014 onwards. And this case was filed in 2014 itself.
Anything more?
Lordship?
Anything more?
Like one more case, Lordship. So in my humble submission, Lordship, that in this case also, Lordship, against the policy operational guidelines were brought in. And there also, Lordship, it's Supreme Court is in clear terms says that that anything repugnant you cannot do. Then Lordship, page 18.
It should have been the petitioner's case.
It should have been, but let's say it is helping me. So
It
Lordship,
has become respondent's case.
I have placed it, Lordship. Please do recollect, you know. Lordship, page 48, Lordship.
Yes.
Here also, Lordship, the same proposition of Vadilal. Here also, Lordship, this case was referred, but the distinguishable factor is again, Lordship, the eligibility certificate was already given. Page 53, relevant part here, Lordship. Page 53, Lordship, that maintainability of writ appeal, then paragraph 15, I'll rely, Lordship. So here also that Vadilal case was referred to. And the same was distinguishing factor is that there also the eligibility certificate was already granted, then sales tax department came in, then said they wanted to cancel it. So then, Lordship, the question of the government speaking into voices come. In our case, Lordship, it's a totally different because eligibility certificate was yet to be issued. Then I'll not read out, Lordship, the same thing. So I will not repeat and take your Lordship time. Page 58, Lordship, another case they have relied at Lloyd Electric and Engineering, Lordship. So they are page 63, Lordship, para 18. A small paragraph, Lordship, I'll just read out.
Yes.
The High Court, with great respect, has gone wrong in not appreciating the background of the case and the decision of the Council of Ministers to extend its own industrial policy announced in 2004 and a tax concession beyond 31/3/2009. Once the Council of Ministers takes a policy decision, the implementing department cannot issue a notification contrary to the policy decision taken by the government. That is the paragraph. Lordship, another few cases, but Lordship, my senior has placed on promissory estoppel, stating that because of the operational guidelines have come into play, the policy was there. So there were some sets of promises have been made, and they have altered their position because of that. But Lordship, my humble submission will be that policy is the promise. Operational guidelines, very object of the operational guidelines, those are not promises at all. Though
Write down the point.
Lordship, I'll write it down. So that is my submission. The promissory estoppel will not be operative against the operational guidelines. Because those are not promises, those are only to execute the promises which has been made under the policy. So in my humble submission, Lordship, this case does not warrant your Lordship's interference. So I'm concluding. Obliged.
By Tuesday? Or by tomorrow? Your points, writing,
My points, Lordship.
writing,
By
writing?
a couple of days, Lordship. Today's,
I think it will be better to deal with.
Ultimately, there, my lord, the entire issue is regarding the tax benefits. So for the other benefits like, my lord, loan incentive, APDCL incentives, whatever is there, my lord, at a subsidized rate. They have no objection on that part. Only, my lord, taxation part is, my lord, there. For which, my lord, they could not get the.
Because since it is bulky, if you point out the
No, I'll-
paragraphs,
we'll
then
do
it
it,
will
we'll
be
do it.
easier for the court.
We'll do it.
Yes, Mr. Gogoi, how much time it will take?
Let it be, my tomorrow or, my lord, Tuesday, any day, my lord, right? So
Not
otherwise,
tomorrow.
I'm prepared.
Not tomorrow, not tomorrow.
Yes, at least on Tuesday, my lord, if possible. Your lordship may. give me
Tuesday
at
or
least-
Wednesday, whatever you want.
Yes, person to my.
Tuesday, I'll not block.
On
Because,
Wednesday in that case, man.
Wednesday.
At 3 or 3:30 anytime, I'll hardly.
After the division bench, because.
Yes, fine.
Okay. Mr. Hart, Mr. Dr. A. Saraf, Learned Senior Counsel, assisted by Mr. P.K. Bora, Learned Counsel for the petitioner, and Mr. B. Gogoi, Learned Standing Counsel, Finance and Taxation Department, and Mr. S. Das, Learned Standing Counsel, AIDCL, are present. First of Mr. Kolita has concluded his submissions. And has submitted that he will file, he'll submit a written synopsis on Wednesday. Mr. as sought for by Mr. Gogoi. Learned Standing Counsel, Finance and Taxation Department is the case on Wednesday. Both you also.
Yes, your lordship.
2 page.
2 page.
2 page. Only 2 page. Point. Main point.
Yes, your lordship.
Page or paragraph decision.
Lots.
And decision also paragraphs.
Lots.
This is an relevant paragraph, your lordship.
Relevant paragraphs. Basically what you are referring to from the decision.
Yes, sir.
Right? And whatever the contentions.
Okay.
5, 6 contention, 1 line, 2 line, then I'll remember.
Lots.